Good morning. That's all good. All right. Are we all set to go? I declare open this public hearing for the Senate Legal and Constitutional Affairs References Committee inquiry into the adequacy and efficacy of Australia's anti-money laundering and counter-terrorism financing regime. I'm Senator Kim Carr. I'm chair of this committee. I joined in the room today by Senator Deborah O'Neill, Senator Ciccone and Croghan and McKim, and Senator Scarr will be joining us via teleconference. I remind senators and witnesses appearing remotely to mute their telephones and your microphone while you're not speaking to limit audio interference. Those participating by teleconference should state their names clearly and each time you speak for the benefit of both the senators and for Hansard. Committee's proceedings today will follow the program that has been circulated. These are public proceedings being broadcast live via the web and in Parliament House. So I remind witnesses that in giving evidence to committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, which we call in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the grounds upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. Now, if the committee determines to insist on an answer, a witness may request that the answer be given in camera, and such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphones to assist Hansards in recording proceedings. Mobile phones and other electronic devices should be switched off or returned to a silent mode. And so with those formalities over, I would welcome our witnesses today, and I thank you for giving us evidence. I would ask that if you would please, I take it that you've all been informed about your rights under parliamentary privilege. The Secretariat has made that available to you. That's the case? Thank you.
Yes.
The committee has received your submissions, number 6, 8 and 12 respectively. And I would ask, do any of you or each of you wish to make any corrections to your submissions?
No.
They stand? Good.
Yes.
Would you please state your full names and the capacities in which you appear today?
My name is Anthony Quinn and I'm the founder and director of Arctic Intelligence.
Thank you.
My name is Neil Jeans. I'm the founder and principal of Initialism AML-CTF Consultancy.
Thank you.
Patrick Oliver, Managing Director of AML Experts.
Thank you. So would any of you like to make an opening statement before we turn to questions?
Yes, we would.
Shall I go? Sure.
I'll go first. Good morning, Senators. Thank you for the opportunity to appear before this committee. Details of the firm and my experience are contained in our submission. I highlight several of which may be of relevance for today's hearing. I currently advise as the Managing Director of AML Experts and a lawyer on the AML Act and rules, both from a legal and consulting aspect. So understand the complexity of both the law and the difficulties of a reporting entity faces in the design and implementation of a compliant AML programme, and I've done so since 2006 at the commencing of this regime, so I'm long in the tooth. I've advised firms, law firms and legal regulators on implementation of AML laws in the UK, Ireland and New Zealand. In Australia, this has been limited to money laundering and financial crime risk. I've advised law firms on risk management, strategy and processes, including anti-money laundering. I've been an AUSTRAC authorised external auditor and an AML court expert. A couple of points I'd like to focus on from my submission. Firstly, the Commonwealth's ongoing breach of both FATF recommendations and the objects of the AML Act places Australia at risk in the international sphere, and also Australian society at risk at domestic level from ongoing serious and organised crime. Secondly, the current AML laws and rules as they apply to reporting entities are overly complex, making it more expensive and problematic for reporting entities to comply than is actually necessary. Complexity arises from many aspects, including the definition of designated services, to complex know your customer rules, and to the all crime suspicious matter reporting obligations. Thirdly, the extension of AML laws to designated non-financial businesses and professions, Tranche 2, is entirely feasible with the political will. Yes, it will impose costs in those professions, but not as much as some have argued. Those costs can be reduced by ensuring any extension is limited both in scope and breadth, by following FATF recommendations and the simplification of the AML rules. Finally, greater compliance with the AML Act, which would result in reduced money laundering and serious crime risk, and better AUSTRAC reporting, would be assisted by a civil penalty provision placed upon directors, owners, senior managers of reporting entities to take reasonable measures to ensure that a compliant AML programme has been implemented. The current governance provisions at reporting entity level do not ensure this outcome. Thank you.
Thank you. I'd like to make a
Yes,
statement.
Mr Quinn.
Thank you very much to the committee for giving me the opportunity to attend the hearing today and for allowing me to present my opening statement. In my career to date, I've spent over 15 years operating in the financial crime risk management sector, including over 8 years at Macquarie Bank, where I was the Program Director responsible for implementing both the AML, CTF and FATCA programs for the Banking and Financial Services Group. In 2015, I founded Arctic Intelligence, which is a regulatory technology firm that provides enterprise-wide financial crime risk assessment software to hundreds of clients in 10 countries and 21 industry sectors, including banks, credit unions, stockbrokers, money remitters, wealth managers, casinos, clubs, and many small businesses in the legal, real estate and accounting sectors. We help them to cost-effectively conduct financial crime risk assessments and develop strong control frameworks. When you're hearing us talk today about financial crimes, we're talking about crimes like money laundering, terrorism financing, human and wildlife trafficking, environmental crimes, bribery and corruption, tax evasion, fraud and violations of sanctions laws. Financial crimes are reported to cost the Australian economy around $50 billion a year, but the human cost of financial crime is incalculable. Australia has a major drug problem. Tons of drugs are imported here every year, and over 1.3 million Australians have used ice within the last 12 months. There's been a significant rise in drug-related gang violence, with murders and shootings happening almost every week, and we've seen a significant rise in drug-related domestic violence, addiction and suicide, which is having a devastating effect on our families and our communities. Organised criminals use many sectors to clean the proceeds of crime, including many sectors that are currently unregulated in Australia, but are regulated in almost every other country in the world. The three key messages from my submission that I would like to read to the committee are as follows. The first point is that the Australian Government has repeatedly failed to take the necessary actions to meet the Financial Action Task Force recommendations and has disappointingly lacked the political will and resolve to take action to address the many deficiencies the FATF has highlighted in various mutual evaluation reports going back many, many years. As a result, Australia is simply not meeting its international commitments and remains one of 5 out of 200 FATF member countries that have failed to expand the laws to lawyers, accountants, real estate agents, high-value dealers and trust and company service providers. This inaction makes Australia an attractive destination for organised criminals and may even result in Australia being grey-listed by the FATF, further damaging our international reputation. There is clear evidence, internationally and domestically, that these sectors are actively used by organised criminal networks, and Australia is no different to the other 195 countries that have already extended these laws to these sectors, many for a decade or more already. The second point I'd like to make is that since the risk-based approach places a responsibility on regulated entities to first identify and assess how their businesses could be vulnerable to financial crime, and then build an appropriate set of controls to manage these risks, there needs to be simplification and standardisation of financial crime risk assessment methodologies. to make it easier for regulated entities, as well as AUSTRAC, who are not equipped to provide oversight to tens or hundreds of thousands of entities adopting completely different risk assessment methodologies. We believe that through the broader adoption of technology, we can improve the overall effectiveness of financial crime risk management, drive down the costs of compliance, and reduce the levels of non-compliance that exist across many sectors. The final point I'd like to make is that there is a lack of clearly defined roles, responsibilities, accountabilities and sanctions for board directors and senior management in the event that a reporting entity has materially breached the AML laws or rules. There is currently no mechanism for AUSTRAC to seek civil penalties against individuals, which was another criticism levelled at Australia by the FATF in its 2015 Mutual Evaluation Report. The lack of consequences for individual board directors and senior managers has created an environment where understanding AML risks and controls is often not given the attention, the focus or the priority it deserves, which has been highlighted as an issue in many AML enforceable undertakings. A related issue that impacts the ability for executives to provide effective governance and oversight of AML programs is the current lack of any mandated timeframe for conducting independent reviews, which in many countries such as New Zealand occur at least every 2 years and should also be adopted in Australia, which will reduce the likelihood of control deficiencies remaining undetected and unresolved for many years. To close and to reiterate the main outcomes I would like to see from this inquiry, they are: 1, to expand the AML laws to tranche 2 sectors; 2, to explore ways to standardise and simplify enterprise financial crime risk assessments; 3, to increase personal accountability for material non-compliance; and finally, mandate that independent reviews are to be conducted at least every 2 years. There are thousands of risk and compliance professionals working tirelessly to protect Australians from the devastating effects of financial crime on our society. It is long overdue for politicians to play their part. Thank you for your time and for listening.
Thank you very much, Mr. Quinn. Mr. Jeans.
Thank you very much. I would like to thank the committee for inviting me to give evidence to this important inquiry into Australia's AML-CTF regime. I represent Initialism, a consultancy that provides AML-CTF compliance and risk management services to businesses of all types and sizes covered by the AML-CTF Act. I have a background in financial crime risk management spanning almost 30 years, which includes working in law enforcement investigating complex financial crime and money laundering, working as a regulator developing AML regulation, working at senior levels within global financial businesses, as well as consulting on AML-CTF in Australia and internationally for the last 10 years. Australia's AML-CTF regime has not appropriately matured or adequately evolved since its inception in 2007. This has resulted in a regime that currently does not comprehensively address Australia's money laundering vulnerabilities and falls short of minimum international standards. As a result, Australia is increasingly considered a laggard in the area of AML-CTF and consequently perceived as an attractive haven for criminal proceeds. The weaknesses in Australia's AML-CTF regime were identified by the FATF Mutual Evaluation in 2015. The findings of the FATF were replicated in the government's own 2016 Statutory Review Report. In 2014, Australia was one of the first countries to be subjected to the current FATF evaluation process. However, since 2014, over 150 countries have been assessed by the FATF, and like Australia, many have found themselves needing to improve their AML-CTF regimes. However, unlike Australia, many other countries have over recent years made concerted efforts to address the weaknesses identified by the FATF. Australia's inaction is evidenced by the appendix that accompanied the Department of Home Affairs submission to this inquiry, which sets out that 49 of the 84 recommendations from its own statutory review in 2016 are either ongoing or outstanding. In 2017, the Attorney General's Department, which at that time had carriage for AML-CTF, published a comprehensive plan to address the statutory review report recommendations that would have been completed by mid-2019. This plan was never implemented. Australia now has only a limited window of opportunity to address the weaknesses in its AML-CTF regime. In 2020, it is anticipated the FATF will review Australia's progress against the 2015 findings. This follow-up review has been delayed since late 2019.
Mr. James, can I just interrupt to clarify? Did you say 2020 then in that?
2022 that they...
Thank you.
Next year. Thank you. As recently as 2 weeks ago, the FATF President expressed frustration at member countries who are not aligning their AML-CTF regimes to the FATF standards, citing a lack of political will as a consistent contributing factor. Whilst the weaknesses in the AML-CTF regime are multifaceted, Initialism's written submission to the inquiry focuses on 3 topics that result from a failure to mature and evolve the regime. Firstly, the appropriateness of using designated services to determine whether a business is caught by the AML-CTF Act. The current designated services are out of date with industry reality, and this hardwired inflexibility has created different compliance obligations for businesses offering similar financial services. Secondly, there is a need for more formalised board and senior management AML-CTF compliance, responsibility, accountability and sanctions. Board and senior management responsibility and accountability are vital tools in ensuring businesses devote appropriate attention and resources to AML-CTF compliance. Finally, the need to bring designated non-financial businesses and professions into Australia's AML-CTF regime. This will close a gap that allows criminals to exploit the legitimate services provided by legal, accountancy and real estate professions to launder the proceeds of criminal activity in Australia and internationally. It is my experience from my time in law enforcement that businesses within the designated non-financial business and profession sectors can be used, either unwittingly or wittingly, to launder the proceeds of transnational organised crime. Since 2018, Initialism has worked with New Zealand designated non-financial businesses and professions. I therefore have direct experience and insight into the actual impact the introduction of AML-CTF will have on these sectors. It is this experience contrasts with other submissions made to this inquiry that claim that the effort and cost are barriers to these sectors being brought into the AML-CTF regime. I look forward to answering any questions the committee may have.
Thank you very much, and I thank the 3 of you. I just, for formality's sake, the document you've sought to table, that is the additional information dated the 9th of November, inquiry into the adequacy and efficacy of Australia's AML-CTF regime. And since there's no objections, we'll take that as tabled. And for formality's sake, the press be admitted. There's no objections to that?
No objections.
No objections and so that's so be it. Well, I might begin with Senator Scarr, if you would like to kick off for the committees, from the committee point of view.
Sure. Absolutely, Chair. Thank you very much, and thank you for all of the witnesses appearing today. Obviously, you all have a great depth of expertise in relation to this area, and it's much appreciated that you join us today. Just to make it somewhat easier, I might direct my questions to Mr. Jeans if I can, and if the other witnesses want to add any points with respect to the questions I ask, then through you, Chair, they should feel happy to do so. So, Mr. Jeans, I read your submission in detail and also read the paper which Initialism prepared in relation to extension of the AML-CTF regime to designated non-financial business and professions into Australia. Can I take you to the second page of your submission? And I'll just quote it. You say that one of the barriers to entry has been, and I quote, the debate about Australia's inclusion of TNFVPs in the AML-CTF regime has been bogged down by a lack of apparent political and federal government inaction, which has been justified in part by the hyperbole, scaremongering and catastrophic impacts predicted by the lobbyists for some DNFVP sectors, end quote. I'm just wondering if you can expand upon that in terms of how you're characterising the opposition of the extension of the AML-CTF regime to DNF BPs?
Thank you, Senator Scarr. The opposition is long-standing. It primarily comes from the legal profession, who have consistently, in many countries, resisted the implementation or the imposition of AML-CTF into covering their sectors. That consistently has been found to be not necessarily the issues or the concerns they have been consistently found not to be correct or not to be appropriate, and that also includes New Zealand, who have recently gone through this process. I worked closely with before the legislation came in, and there was a lot of fear and concern within both the legal sector, the accounting sector, and the real estate sector. But 2.5 years on, this is part of normal business. So, I've been working in this space for almost 30 years. Since 2003, lawyers, accountants, and real estate agents have been trying to be brought into the regime by the FATF standards, and there's been a consistent campaign, which in every country that I've been involved in has lost credibility, and the reality is found to be different.
Okay, can I take you then to the Law Council of Australia's submission? So have you had an opportunity to read their submission?
I have, yes.
So I read that submission, and from my perspective, they're raising bona fide concerns with respect to matters such as legal professional privilege, the prospect to manage these issues in a way through existing professional conduct rules and standards, and also a concern with respect to the disproportionate impact this could have, in particular in an Australian context, on sole practitioner firms, because a lot of our regional and rural communities are serviced by sole practitioners who do everything, all the legal work in the town, they do it. And there's a real concern that this regime, if it's not calibrated the right way, could have a disproportionate impact on them. Do you recognise that these are legitimate bona fide concerns that are being raised by the profession?
Firstly, I maybe refer to Mr. Oliver to address the legal privilege and confidentiality. As a practising lawyer, I think he's well placed for that. And then, if we may come back to the costs, which are part of the submission we have made, the additional information we've made.
Mr. Oliver?
Can I just ask Mr. Oliver when he answers, because he'd refer in his submission to the 3 jurisdictions in the UK where they had all different situations with regard to law. If you could reference that in your answer, that would be helpful. And Senator Scarr, your next question might be assisted by the extra document we just received. I don't know if you've got it yet, but you might want to have a look at that. Thanks.
In relation to legal professional privilege and client confidentiality, they are quite extensive and complex legal ethical rules to understand. Legal professional privilege is related to legal advice and to litigation. The AML Act itself says legal professional privilege will not be abrogated. That's section 242. The Law Council say that's not strong enough in their submission. That's open for debate. Interestingly, New Zealand did put an extra amendment into their law when they changed it to bolster that. So legal professional privilege will not go away. Client confidentiality is a broader concept that all client confidential discussions with lawyers should be confidential. However, there are exceptions. One of the main exceptions is if it's allowed by law or demanded by law. That's section 9.2.2 of the Australian Conduct Rules. So that can be dealt with as well. So those issues, although they are complex, and in the UK and Ireland, it did take quite a lot of thought about how those can be overcome, but they are overcome. It's now not an issue in the UK and Ireland about those areas. It does actually help that lawyers end up with more training in relation to their ethical obligations. Training is a major piece in that area. And in relation to the proportionality of the rules or the laws, I think we're all arguing that the rules are complex. If they are correctly implemented and perhaps change the AML Act, the impact on those smaller law firms will be not as much as the Law Council has said. Ireland and the UK and New Zealand is full of small law firms. yes, there was an impact, but they still exist. Now, there might be insurance issues which cause law firms to merge, but that's from an insurance perspective, not from the implementation of the anti-money laundering laws. And I was involved in helping law firms in 2003 and 2004 in the UK and Ireland in implementing those.
Mr. Oliver, are you aware that the Canadian Supreme Court actually overturned certain parts of the anti-money laundering laws in Canada
I am.
on the basis that they were contrary to principles relating to legal professional privilege and lawyer-client confidentiality, that the Supreme Court of Canada actually overturned some of those laws on that basis?
I have read that case, yes.
So doesn't that suggest that, I mean, we can talk about how we adapt the laws to the legal profession, but it does suggest to me that there's a real issue here, an issue of substance in terms of how you calibrate these laws, how you apply them, and how they should fit to the legal profession. There's a real substantive issue here. Would you agree with that?
Well, I agree that the fact that they have to be adapted.
Okay. So you referred to the imposition of the laws on the UK legal profession. Is it your view that that these laws have now been bedded down and there are no issues, or are there existing issues in the UK?
In relation to the 3 UK jurisdictions, they have been bedded down. They've been in place since 2004 or 5 when they implemented the 3rd European directive, and there were some other issues around the Proceeds of Crime Act then. They have been implemented, they have been tweaked. One of the most important things in the UK is the slightly different regulatory model where the English and Wales Law Society has, for the want of a better phrase, very detailed guidance, which once a law firm follows that, they basically have safe harbour against any of the rules, and that guidance is very good. The regulatory model is different. They have a Solicitors Regulation Authority, which does take action against errant solicitors. In Scotland, the Law Society of Scotland has a similar system, and similar in Northern Ireland, and England and Wales is one jurisdiction.
Okay. Are you aware that Treasury in the UK is undertaking a review of the AML laws?
I am.
Okay. Have you had an opportunity, and look, you probably haven't, and I'm happy to maybe provide the witnesses a copy of this, just so they have an opportunity to respond and they could take it on notice. But I just want to read to you and get your reaction to a submission which the UK Law Society has made to that review of the laws, and this is dated 19 October 2021. Are you aware of this submission from the UK Law Society?
I'm aware of it, but I've not read it.
Okay. I'll just read these paragraphs to you to get your reaction. While we welcome HMT's commitment to making the AML regime proportional and effective, the current regime does not promote a risk-based approach. Instead, it drives ticker-box compliance to satisfy overly prescriptive requirements. This is a particular challenge for small firms. The current AML regime places disproportionate compliance obligations on the legal profession, requiring activity that does little to prevent money laundering, the cost of which is ultimately passed on to consumers. The AML system is designed with the financial sector in mind, so any reforms must address the different issues faced by the legal profession, and they must be evidence-based. The current regime's ticker-box method undermines the effectiveness and proportionality of the measures and drives up costs for legal services consumers. We look forward to helping develop and apply a regime that is both proportionate and effective in tackling economic crime, as well as being workable for our members. End quote. Mr. Oliver, can you understand that when I read this, and I'm not an expert in these matters as you and each of the other 2 witnesses are, that it raises a red flag in my mind that we have to be quite cautious in terms of extending this regulatory regime, both to the legal profession and also more broadly in terms of accounting and real estate businesses, which in many cases are small businesses, which during this period of time have been absorbing all sorts of costs, and the last thing they need at this point in time is disproportionate regulation, which will simply drive up the cost for their end consumers. Can you understand us being, or at least I'll speak for myself, being wary in terms of imposing those costs when we read those, when I read that submission coming out of the UK Law Society, which has been dealing with these issues for over a decade?
Well, from the quote, and I actually have seen that quote in in a press release from the English and Wales Law Society, it doesn't appear to me to be arguing against the AML laws. It's arguing for a more risk-based approach, which Australia has or would be implementing anyhow. So I think that's not an appropriate argument in Australia.
Senator Scarr, have we still got you? Can we find out what's happened? Just bear with us for a moment. It's the joys of the remote technology.
It's good when it works.
Exactly.
I have very little confidence in it, so. What's
We
happened?
had the real NBN.
Exactly.
Well, it is interesting being questioned by the
Well,
Television.
while we're doing, I mean,
by the.
can
By a
I,
blank
to
screen.
fill in a question while we're waiting, I'm going to turn to you in a moment. So is it your argument, it's not a question of regulation, it's the calibre of regulation?
Correct.
That this, like all small businesses, the issue of how they fit within the broader regulatory environment is the real issue here, not whether or not they fit within the regulatory environment.
Absolutely.
Correct, and that applies to current reporting entities, the small, which are many are small businesses. In fact, the
Yeah.
majority would be small
Or
businesses.
accountants, for instance, the taxation department wants to know whether or not accountants are behaving ethically and properly, and no matter what the size of the accountancy firm.
Exactly. And if you go back to the FATF and you go back to the services that would be covered, they are very limited. They are conveyancing, the establishment and maintenance of companies, and managing the financial affairs of companies and people. So it is a very narrow set of legal accountancy services that are actually called by this piece of legislation, or should be called by this piece of legislation. That undoubtedly results in a narrowing of the impact, just
Yeah.
simply by definition.
Now, there is an argument about whether or not the risk-based approach is in itself adequate.
Of course. I've been involved in the risk-based approach since its inception in the early 2000s. And the risk-based approach is not a panacea for all ills. It is something that needs to be worked on. You need to understand the risk and then adjust your program according to the risk. That risk-based approach also includes AUSTRAC playing a role in granting exemptions to certain parts of the Act and the rules to certain business cohorts, which they have done consistently already. For example, reducing the impact on pubs and clubs unless they've got over 16 poker machines.
Yes.
So there is precedent already that this legislation can be flexed and adjusted to meet the needs of these business sectors. So, yeah.
Well, have we got Paul back? No good? All right, I might... that's it. So, Senator Scarr, are you there?
Yes, I am here, Chair. Sorry about that. The connection.
So we've had in the interregnum a short discussion about the nature of regulation for small business. I think that's to sum it up. Do you have any further questions? Because
No, look, I'm happy for you to pass the call on. To
okay,
other senators.
Senator O'Neill, would you like to take up the call, please?
I would. There's so many questions arising out of both of the conversations. Firstly, Mr. Jeans, you indicated in your evidence to us today not only that the risk-based approach needs more simplification, but you actually said AUSTRAC is not equipped for the task.
I think that was
Oh,
me.
Mr. Quinn.
So
Yes, thank
my
you.
point there was really AUSTRAC, and I think they should be commended for the risk assessment guidance that they've provided various industry sectors, because they do have kind of detailed understanding of different risks. My comment there was really around the fact that there is no real standardised approach to conducting risk assessment. So you may have a list of risks for the types of customers that you deal with, or the types of products or services you offer, or how you offer them, but no structured or standardised methodology for how those risk assessments are conducted. And currently there are 16,000 regulated entities in, across not just financial services, but clubs and pubs, gaming, bullion dealers of different sizes. Were the regulations to expand to those tranche 2 sectors, I think that there will be benefit from having more standardisation and simplification, which is really where we believe as a firm that technology can play a role in that. We're already providing, guidance and support through technology to simplify this, to help regulated entities to really understand the vulnerabilities that their business could be exposed to from a money laundering perspective. But not just that, but looking at the types of controls that are both appropriate and proportionate, rather than just here's a bunch of risks. What types of controls do you need to put in place
To make it effective.
to make it effective? How do you conduct control effectiveness testing to determine whether your controls are designed properly, whether they've been implemented properly, and whether they're actually operating effectively and how effectively they are. And so there's a lot of kind of tools and technology that is available now that was not available when the Tranche 1 regulations came in Australia in 2006. And there's many
Phones have changed a bit since then, if people want to think about technology changes.
Exactly.
And the technology's changed to make this much more likely to be successful in an efficient way. You indicated that 195 countries have been able to get Tranche 2 done, and Australia's one of 5. I think they've been described increasingly, Mr. Jeans, increasingly considered a laggard, and by failure to implement Tranche 2, are attractive to organised crime.
That's correct.
I note the Prime Minister was at G20 just recently and signed off on the statement there. Item 59, we reaffirm our full support for the Financial Action Task Force and the Global Network, and recognise that effective implementation of anti-money laundering, countering and the financing of terrorism and proliferation measures is essential for building confidence in financial markets, ensuring a sustainable recovery and protecting the integrity of the financial system. We're not talking about a little thing here today, are we? This is quite significant for Australia as an international, global citizen, that we come to the party and catch up to the game. Mr. Jeans and then Mr. Oliver?
Yeah, absolutely, 100% correct. And as we sit today, we are really one of 3 countries that have failed to take action out of the 177 that have been assessed by the FATF to date in round 4. Those are Australia, Haiti and Madagascar. The one thing they have in common is they're all islands, but I think we're the biggest island. The other 2 countries that were referenced and reference submission that have moved recently are the United States, where they have introduced legislation, the Enablers Act, into Congress, and and FinCEN, the AML regulator, has started to amend its definition of financial institution under the Banking Secrecy Act to start to include high-value dealers and other designated non-financial businesses. In addition to that, the FATF last month reported in a follow-up mutual evaluation of China that China has actually started drafting legislation that will be enacted, has undertaken a sectoral risk assessment of all the designated non-financial businesses and professions, and actually is in the processing of developing supervisory responses to those risks. So as we sit here today, we are in a cohort of Madagascar, Haiti and ourselves.
And the Australian government actually did some work similar to what you've just described in China happening recently, but they did that back in 2016 and they mapped out the pathway to proper international responsibility for Australians.
That's correct.
And there were 49 of the 84 recs
Yes.
that were put forward by that remain ongoing. So basically this government's pulled up stumps in about 2016 and said, bit too hard, bit of resistance on the line, don't think we'll bother.
Yeah, 100%. I think the rhetoric around siding up to the G20 is very inconsistent to the actual practice.
You talk about the gap between the announcement and the delivery. We've been noticing that with this government.
100%. I think basically, you're either agreeing to comply with the FATF standards or you're not.
Yeah.
It's black or white.
Yeah.
They're very prescriptive around what they expect countries to do, and they measure them about whether they're partially or fully or not compliant against those.
So signing up to this document's a bit of, smokescreen con job. The reality is there's work to be done and it isn't being done. That puts us at risk, not only in terms of the movement of money, being a honeypot for organised crime and financial crime more broadly, but puts us at risk of going onto the grey list. Could you explain what that means and what are the implications for the broader Australian economy of going on the grey list with FATF?
So the grey list is basically a list of increased monitoring. So as a data point for the committee, Turkey was put on the grey list a couple of weeks ago. Turkey is also a full member of the FATF. It's one of only two members of the full members of the FATF that's been put on the grey list, the other one being Iceland, which was removed because the government there moved very quickly to be removed from the grey list because they understood the economic impacts of being put on the grey list. What basically the grey list says is that other countries should have regard to the weaknesses in a particular country's regime and make sure those risks are appropriately mitigated. They don't necessarily recommend enhanced due diligence on everything, but what we see by definition is that this could have impacts on the financial institutions being able to operate internationally because they would be required to be subject to more scrutiny on a transaction-by-transaction basis. It could also see impact in relation to access to capital markets. So therefore, this has a real-world economy potential impact.
So we're talking about significant slowdown and stickiness in the way money can move around the country.
That's right.
If we get on the grey list.
Potentially, yes.
Also, in terms of financial access and Australia's role as a significant financial hub for the Asia Pacific, could you reflect on what would happen to our status if we end up on the grey list in terms of our regional capacity to play, I suppose?
Well, again, it would be the same because Singapore, Hong Kong, Indonesia are also members of the FATF, so they would have to take notice of any grey listing. So therefore, that would ultimately, obviously, impact the ability of Australia to do business in those countries, obviously including China and Japan and other countries, and obviously New Zealand as well. So, and the FATF grey list is not the only grey list. The EU have their own separate grey list, which obviously the EU will consider whether Australia is meeting equivalent standards to the EU standards, and they have the ability to put Australia on an EU grey list.
Well, there's been a bit of attention to Australia recently by key participants from the EU, including the French president, who called our Prime Minister a liar. So there might be a little bit more attention focused on us and our compliance with FATF in that climate.
And also Mr Macron is soon to be President of the EU.
Indeed. I do have another line of questioning, but I just want to give you the opportunity to put on the record the additional material that you put in here, because this seems to be a counter-narrative to the it's going to cost us a fortune to do this and we simply can't consider. Australian businesses are not able to cope with the cost of the implementation despite the rest of the world doing it.
Yes.
Could you speak to this document, because it does go to some detail about what's the reality as you perceive it as experts?
Absolutely, and I think we'll share that because it's a joint submission between all three parties. Paddy, would you like to lead?
It's based upon our experience of helping current reporting entities, large and small, with design and implementation of AML programs. It starts with what their current business practices are, and then what we did was we mapped what, for instance, a law firm should be doing. The hypothetically well-run law firm should be doing most of those things in that in the table, and then we mapped what additional work, if any, would need to be undertaken in that business to design and implement appropriate AML program as the law currently stands. Hopefully, it wouldn't be to that standard. And we then provided what we thought the costs were. I do know that there was the Queensland Law Society survey in 2017 or 2018, which did come up with some fairly large costings. I actually completed that survey. It was designed for one reason only.
So, Mr. Oliver, to be very clear, you're telling us that as a form of resistance to the Tranche 2, that there has been deliberate and willful construction of hyped up costs for the implementation of Tranche 2 that really don't reflect the reality of what it would cost to bring in these protections.
The survey itself was designed with one goal in mind, which was, in my opinion, to heighten the cost, the potential cost for implementation.
And the figures that you've provided us with here in your submission,
Yes.
on what do you base them?
Practical reality.
Yeah, I mean, that survey was undertaken in 2017. It's 2021 now. There's
Things have changed.
massive advances in technology in terms of the KYC space. Like each of these line items in terms of collecting and verifying customer information, doing PEP and sanctions screening, doing individual customer risk ratings and rescreening notifications. All of that could be done by modern KYC providers for under $3 per client. So each of these are kind of added up, compounded, and in my opinion, massively overstating the cost of compliance.
And if you analyse, to give you some examples, if you analyse the submission and the Queensland Law Society survey, they're estimating for a law firm to understand why it's acting for a client, because that is the requirement to obtain information regarding the purpose and the intended nature of the client matter, to actually understand why they're here in their offices and undertaking work, that is going to cost them between $50 and $122. Well, isn't that just part of normal professional practice? We can't see really there's a cost there.
Yes.
As Anthony said, the cost of customer due diligence has come down exponentially because of technology, because of the solutions that have been provided. So, and having worked with law firms in real estate accountancy and law firms up and down New Zealand for over a year, the average cost of a law firm was $10,000, and that's a small law firm and a medium-sized law firms. To put in place a program, to put in place a risk assessment, and to adjust the systems and controls they have already to meet the obligations. And the obligations in New Zealand are more severe than they are in Australia. There are particular obligations that are more draconian than we have currently here. And then uplift make some changes in terms of...
Two more questions if I can.
Well, can we...
Come back?
Yeah, I'll give Senator McKim the call and come back, if
Thank you
that's
very
all right.
much, that'd be great.
Thank you.
Senator McKim, are you there?
I am here, Chair.
Would you like to take the call and then we'll come back to Senator O'Neill if we get the moment or two at the end.
All right, thanks, and good morning, folks. Thanks for your submissions and your attendance this morning. I just wanted to explore a little bit further this issue of costs, and thanks for your supplementary statement this morning. The Law Council has estimated that the cost to a small law firm, and they define that as a firm of between 1 and 5 solicitors of Tranche 2 compliance, this is the total cost, would be around $119,000 per annum. Now, you've provided some evidence in your supplementary submission this morning on what you think the actual cost would be, but in total, like what's the... And also you've given evidence that that basically you think the Law Council's trying it on, I guess, that's my words, not yours. What would the total quantum in approximate terms be to a small law firm of between 1 and 5 solicitors for complying with Tranche 2?
Yeah, we've estimated that to be $10,000. So basically the Law Society estimates are over 10 times higher than that. And I think some of that is a symptom of when that survey was conducted, because things have moved on significantly. So costs of risk assessments and AML programs, KYC, employment screening, training, all of those things that are requirements are very cost effective, and I think the costs here are significantly overinflated in our experience. What we're charging as a technology provider, what we know of our peers that charge their customers for doing all of these services.
And that would include a degree of consulting services to help the organisation understand what AML CTF compliance means, to train their staff, to adjust their systems and controls, to put in new procedures in the areas where they would be needed.
There's also
And just to be, oh, sorry, Kat, please.
There's also the fact that a well-run professional firm should have good client intake, should have good risk management, should have good policies and procedures, should have good training. Now, the cost then probably is reduced. A firm which is not so well run will have to do uplift, but that's no bad thing.
Thank you. And can I just ask, is your estimate collectively based on your experience with other countries that have introduced Tranche 2 that have similar legal frameworks to Australia?
Yes.
Yes, it is.
Yes, this is New Zealand. Basically, this is our experience in New Zealand in 2018, where we spent a significant amount of time working with lawyers, working with accountants, working with real estate agents to get themselves AML compliant to a piece of legislation which is 95% the same as Australia's.
Thank you. And in your experience in places like New Zealand, would the cost burden on accountancy firms and real estate agencies be of a similar quantum?
Yes.
It would. Okay. Thank you. Look, I just wanted to explore a couple of other issues briefly before we run out of time. Firstly, just to be clear, it is your submission. I know you mentioned this, Mr. Jeans, happy for you to respond, or any of your colleagues there, but is it your argument that Australia is actually more attractive to people who want to clean dirty money because we are such a laggard in international terms, and because we are, along with Haiti and Madagascar, one of the only 3 countries that's not moving significantly or have already moved in that area? Is that your evidence?
That is my evidence, yes. And this based on experience, obviously, based on my law enforcement experience, which I appreciate is somewhat dated now, but criminals were using corporations, trusts and other legal vehicles to conceal their ownership of assets, and that includes real assets such as property, way back in the 1990s. That is still ongoing now, and you can see the amount of money that's flowing into the country. These legal entities, these legal structures, create a perfect mechanism to be able to conceal ownership, to conceal identity. And simply what this legislation is requiring the law firms and the people that are creating those structures to do is know who they're dealing with, and if they believe the money is suspicious, i.e. from criminal conduct, report it to the appropriate authorities. That is the basis of this legislation. It's the same thing for banks, for financial institutions, for pubs and clubs. It's understand who you're dealing with, understand why they're using you, and if you believe that is suspicious because you believe it is there's criminal activity, report it to the authorities.
One of the outcomes of the professions not being caught by the AML Act is the lack of awareness of just general financial crime risk to those businesses. I have given plenty of AML talks around the country, and I do get some interesting hypotheticals afterwards.
So, can I just cut in on a minute, just for what? Can you, any of you gentlemen, give us a estimate of the amount of unreported money that's flowing into the country or is not being captured by the current regulatory regime, covered by these entities that you believe should be part of the regulatory regime? Have we got any sense of the size of the problem?
I think that would best, when you say flowing in, so one method would be for the funds to come directly into trust accounts. That would be caught by the International Funds Transfer Instruction reports, but whether or not AUSTRAC will be able to.
So you don't have any sense of the scale of unreported monies flowing through real estate agents, lawyers, notables, other legal professions or accountants?
I think, Senator, it's because if the funds come from offshore, they will be subject to FD reporting, but
some form of reporting. But I'm just trying to get a sense of the scale of the problem that you're asking this committee to examine to be fixed.
Yeah. I don't think anybody knows. That's the problem. That's the point. Like, if we don't know how much illegal money is flowing into any regulated or unregulated sector, because there's very little research that's been done in this area in terms of flow of funds into the country. The last estimate was done in 2017, I think, by the Crime Commission, which is about $47 billion impact to the economy.
47 billion.
Yes.
Correct.
That's correct.
And that was, since then we've had, multiple billion-dollar drug busts, multiple over the last. So that number, I would expect, if they were to redo the survey now, that would be higher.
And I think one of the key points is because these businesses aren't captured by the regime, we don't have that level of transparency, because effectively, if they were reporting, we would have to...
It's hardly likely to be a survey question.
Yes.
What's the level of illegal activity in your business?
Yes, absolutely.
Yes. All right. Sorry. Senator McKim, one more
Thanks,
and I'll
thanks,
go
Keith.
Senator O'Neill to finish off.
Yeah, sure. I'll just make this my last question in that case, because I know we're close to out of time. But we've heard evidence from you this morning that there's the chance that the FATF may choose to put Australia on the grey list. Would any of you folks like to hazard an estimation as to the likelihood of that happening? And if so, what's the process and what's the timeframes under which that might happen?
Again, difficult to put a likelihood on because it's a political process. So, but if you look at previous activity, you look at where Australia is in the FATF process. We were one of the first countries to have weaknesses identified. We have, there's been limited action on addressing those weaknesses. Other countries that were reviewed earlier, so take Turkey for example. Turkey's mutual evaluation was in 2019. They have been put on, because there's been that follow-up mutual evaluation, they have now been put on that grey list. So we've been long non-compliant for the longest, and we've done nothing about it. So I think that undoubtedly would increase the likelihood. Yeah. What the process is effectively there is this follow-up mutual evaluation where the FATF send in experts from other countries to come in and review the progress against the findings of the 2015 mutual evaluation. That report is then reported to the FATF Secretariat. It is then subsequently discussed in the following plenary. The next plenary is February, but I would imagine you'll be talking about the July plenary at the earliest, maybe the October plenary, that they would discuss the outcome of that evaluation. And then within that plenary, a decision would be made on what sanctions or what action would be imposed on Australia to amend its ways.
To put it another way, the longer it gets delayed, the higher the probability.
Yeah, and just to add to that, the mutual evaluation report was 2015,
Yep.
6 years ago. They've already 49 out of 84 recommendations that, by their own admission, have not been actioned. Tranche 2 is just one of a list of very many. So, the ball has well and truly been dropped.
And there is the third enhanced follow-up report in November 2018 that indicates much more work needs to be done. Is that the most recent
That is
one?
the most recent.
Thank you.
The most recent one, yes.
Chair?
You've got another one?
I've got a couple, yeah. I'm going to blend them together if I can. Mr. Chevis of Transparency Australia, in response to the Bergen report, wrote, the key takeaway of the report handed down by Patricia Bergen is if you want to get away with industrial scale money laundering in Australia, do it behind a corporate veil and share the blame around. Can I take you to your evidence today that there needs to be formalised AML, CTF principles put in place for which the board members and the senior executives are responsible? Certainly we know from the audit inquiry through the Senate, when we looked at CPS 220 documents and spoke with APRA, there is a prudential risk if you don't do this, and the banks have actually figured out that they needed to sort it out, particularly the Commonwealth Bank and Westpac in response to issues. So my questions go to, is AUSTRAC up to the job? What's their capacity and technical capacity and staffing capacity? how do we give them the capacity to interact with corporate Australia and make corporate Australia responsible for this? And are we in as bad a position as was described there, where people can get away with industrial scale money laundering?
Well, I think to answer that question, I was Austrac's expert witness in both the CBA and Westpac cases, so I viewed the documentation, the evidence that was part of that civil claim, and on that basis, I think Austrac are more than capable of tackling accountability and responsibility. The problem is that the legislation and the rules do not allow them to have the appropriate mechanisms to do so at this point in time. We have seen subsequently that ASIC have attempted under Section 180 of the Corporations Act to consider both from a CBA and Westpac case, and they have struggled with both those cases, and both those have subsequently been discontinued.
Yes.
So I think we have a fundamental weakness here. I think APRA do have the power, but APRA obviously only regulates the financial institution, the banks. It doesn't necessarily regulate the whole code. And if you look internationally, a key pillar of the AML regimes internationally is senior management accountability and responsibility, even down to the money laundering officer being responsible and personally liable themselves. That's making people responsible, making people own well-being and own reputation and own assets be exposed, creates change and creates the appropriate level of focus.
So your evidence really is, if you give Austrac the capacity, which we would do if we implemented Tranche 2, that you have some confidence in their capacity to do the job.
Absolutely, yes.
APRA has sufficient power to manage the situation with the banks,
They do.
but we're going to talk about corporations that we're going to make more responsible, plus we're going to talk about different professions. Are the structures adequate and robust enough there to provide the vehicles, if this legislation were to be enacted, for it to become a practically effective intervention in the laundering of money in Australia?
I think that, as Mr. Jean says, Mr. Quinn has also said, and we've put in my submission, is that having an accountability regime on a person in the Act would go a long way. Because I know from my experience and talking to my peers, when we talk to board directors, first question is, what's the likelihood of something happening to us? And basically nowadays we have to say nothing. There's the sanctions is against the reporting entity, not against the person. Now it would be a long way to go to get a prosecution, but there's no emphasis really for a person in a reporting entity to undertake these, to implement an effective programme.
Yeah, there's no culpability for individuals or their role in, willfully or not overseeing a money laundering incident. There is no sanction on individuals. The organisation might suffer a fine or penalty or have to put in remediation process or be subject to class actions or enforceable undertaking. Share prices go down, but ultimately it's there's no individual accountability, and that's what needs to happen for things to change.
Like Mr. James, I've been involved in an expert witness in a matter, and it just didn't go anywhere because it's too difficult to link Section 180 of the Corporations Act to issues in an AML civil proceedings issue.
So best legislation internationally for us to look at if we're going to lose our international laggard reputation and rise to out of the grey zone, dare I say, because we don't be grey listed, if we rise to the responsibility of being a good international corporate citizen, what should we follow? What is the best legislation that you think is compatible with the Australian model?
In my personal opinion, the United States model is getting there because of the personal responsibility on anti-money laundering officers. The UK regime, and bear in mind the UK regime evolved directly out of the Barings issue, so the Financial Services Authority, which I was part of, was formed because of the Barings issue, which identified lack of management accountability in the collapse of the Barings Bank. And so the principles and the requirements that the SFA enshrined in the work they do is that level of accountability. So I would suggest look at both the US and the UK models as key models.
There's also examples in the Corporations Act on the financial services laws. making my submission. It's relatively undifficult to be struck off or to be banned as a director under a Corporations Act, but no directors ever or senior managers ever had the same sanction under the AML Act. And the AML Act civil proceedings have been multiple times the amount that Corporations Act fines have been.
And none of you made a submission that you thought there should be criminal sanctions embedded, although it is in a couple of other submissions?
There are criminal sanctions already in the AML-CTF Act, but that relates to participating in money laundering, not doing the right thing for anti-money laundering. Yeah. So, yeah, I think the civil regime would be appropriate.
Criminal would go very far, probably too far.
Okay. Thank you. Thank you, Chair.
Well, thank you, and thank you, the three of you, for appearing. It's particularly a great benefit to this committee to have your expertise made available to us. So
Thank you.
appreciate it very much.
Thank you, Chairman. Thank you.
I call the representatives from the Police Association, Police Federation of Australia, and Mr. John Chevers.
Chair, can I just indicate I probably had some questions on notice for the
If
previous witnesses.
you're
that's
prepared to
okay
take
with
questions
them?
on notice,
Thank you.
we'll pick your brains some more.
Thank you.
Thank you very much.
Thank you. Thank you very much. Thank you.
It's very, very. Well, you ready to go? Okay, no problem. So I'd welcome representatives of Police Federation of Australia and Mr. John Chevers, and I thank you both for putting the time today. I trust that information on parliamentary privilege has been provided to you, and if not, there's further information available from the Secretary. The committee has received a submission from the Police Federation, and it's numbered submission 20. So, Mr. Weber, the committee has not received a written submission from Mr. Chevers. I understand that's correct? Yes. Would Mr. Weber, do you wish to make any corrections to your submission?
No, Mr. Chair.
No. So for the Hansard record, would each of you please state your full name and the capacity in which you appear today?
Scott David Webber. I'm the CEO of the Police Federation of Australia.
John Stafford Chevis, and I'm an independent anti-money laundering and counter-terrorist financing advisor and consultant.
Thank you. Would each of you like to make a brief opening statement before we go to questions?
Please.
On behalf of the Police Federation of Australia, I represent over 65,000 police officers from around the country. Our submission highlights that we are really in favour and also want this legislation to be done in regards to making our job easier and also gathering more information and highlighting the issue of money laundering, but also on top of that to actually reduce the not only the fear but also the reality of counter-terrorism incidents occurring in Australia. In our submission, we highlight that we agree with the legislation and we're happy to give further evidence. In regards to examples, it's probably best my counterparts that are giving evidence tomorrow, whether it be AUSTRAC or the Australian Federal Police or the ACIC. I note there's some examples in there as well.
Thank you, Mr. Chevers.
I have a rather lengthy opening address, which I'm prepared
Lengthy.
not to...
That always terrifies the
Yeah, sorry
committee.
about
So what have you got in mind?
It was merely an attempt to try and make up for the fact that I hadn't made a submission under my own name.
Yes, that might be the case, but what have you got in mind all of a sudden?
1,000 words. But happy to skip that and submit that otherwise.
Well, hang on. Would you like to table your statement?
Yeah, sure. Yep.
And if you want to give us a really brief synopsis, just
okay. Yeah.
just to help us get a feel for it, because we won't have time to read it.
Absolutely.
Just, no. And if you could table it now, we would take that as your opening statement as well.
That sounds like a good approach. So my submission covers the fact that the FATF recommendations have heavily influenced Australia's anti-money laundering and counter-terrorist financing regime, but they themselves haven't changed very much in respect to anti-money laundering since about 1990, and they haven't been subject to any sort of evidence-based process to determine how effective they are in actually addressing the underlying crimes. I have a couple of recommendations in relation to Australia's approach to anti-money laundering, an expansion of the collection of data on money laundering to include things like trade-based money laundering, cash-intensive businesses and other areas, separation of the regulatory role and the FIU role for AUSTRAC, the commencement of a national risk assessment on a continuous basis to provide both a basis to understand money laundering and to determine the actual value of funds laundered through various sectors in various areas, and to provide a baseline for the evaluation of the effectiveness of any measures put in place. And lastly, amendments to the Criminal Code offences to provide a meaningful deterrent for money laundering through corporations, as you were discussing earlier. The current penalty is 1,500 penalty units for knowingly laundering $1 million or over, and 1,500 penalty units is about 330,000 Australian dollars, which is nowhere near enough to provide a credible deterrent for laundering by or through corporations. So that's
Thank you.
pricey.
All right, well, Senator O'Neill, would you like to kick off for the committee, please?
Thank you very much, Chair. And our previous witnesses have indicated that, in their view, as experts, that between $47 and $50 billion of money is being laundered through Australia per annum. Mr Chevis, I quoted you to our previous witnesses where you said the key takeaway from the Bergen report is if you want to get away with industrial scale money laundering in Australia, do it behind a corporate veil and share the blame around. So just invite you to sort of give us your view of what's the reality out there that we are still getting resistance to responding to from some of the professions.
Yeah, so certainly the reality, I think, is in that sort of ballpark of about $50 billion, keeping in mind that that comes from various different sources. So we have drug crime, we have fraud, we have corruption, we have foreign predicate offences for which the money is laundered into or through Australia. And I don't think that figure is particularly outside the realms of reality. The laundering through corporations and other sort of entities like law firms, accounting firms and real estate agents is a reality, and the current criminal code doesn't provide a realistic deterrent or an easy way to sheet blame home to individuals. And that's why we're not seeing prosecution of corporate entities for money laundering, because the penalties are so low. And I think in some form there is a real opportunity to either include the designated non-financial businesses and practices in the AML-CTF regime as the FATF would see it in their prescriptive terms, or alternatively beef up the criminal code penalties and modify the criminal code to allow for much easier prosecution of those entities and the individuals within them for money laundering, and sidestep perhaps the need to include them in the AML-CTF Act. The FATF, under the new effectiveness measures, allows for these sorts of differences. In reality, we just need to show as a country that we have achieved the outcome, more so than ticking the box as was perhaps the way back before 2012.
Okay. Mr Webber, did you want to add anything about the impact of this amount of illicit money moving through the Australian economy and what it means on the ground for Australian citizens?
Look, I think we can just see it every day, and you're touching on the figures of the financial year in 2016, 2017, but it would have increased dramatically. And even though COVID's restricts some of the importation of illicit drugs, there's been a massive a boom in the property market. Australia is just that, a place where you can actually divert your funds, illicit funds. We've just had the casino inquiries as well. There's huge issues and huge opportunities for people to do organised crime, and then that folds into other, detriments to the community. Police officers on the ground are seeing this daily, and it's something as simple as illicit tobacco, which is damaging to the federal government's bottom line through taxation, also the health requirements there. But on top of that too, we have criminals out there making a large amount of money from something that should be taxed by the Australian government and also should be properly monitored. So in regards to this, regulating these other professions, as highlighted by Mr Chavis, is totally what we want to see. Again, I don't think it's an onerous task. We're actually playing catch up to all other countries, as highlighted in previous submissions. This is best practice across the world. We need to actually highlight that Australia is a place where people can go about their business freely, but on top of that too, there's certain checks and balances to make sure that they're not eliciting ill-gotten gains, and also they're not laundering money.
So is there evidence to the committee that investment in property and driving prices up is in part from the laundering of illicit money through the property market in Australia?
No, I would not be saying that. I'd be saying that that's a great opportunity. I mean, look at the prices and the booms. I mean, we're seeing places that have gone up, $500, $1 million in 2 or 3 months. Again, if you have ill-gotten cash and you can go to a real estate agent, get conveyancing with the lawyers, and there's no punitive measures, that's a great way to actually launder it through a corporation, through a business, and actually have an investment, and a sound investment, which makes it extremely difficult for law enforcement actually to take back off them if it's done through those mechanisms.
So it's launder and profit.
Yes.
It's a very, very seductive model of business.
That's right. And again, I touched upon illicit tobacco. That's a sensational model in regards to organised crime making money at the present moment. There's a huge markup. There's a huge import of it. A lot of it's not getting detected. And again, a lot of people see it as a victimless crime. Well, it's definitely not, because it's putting money in the hands of criminals that go and do those more serious offences. It's also damaging to the economy, and also damaging to the health of not only general citizens, but especially our young people that are going out there and buying cigarettes at a lower price.
We had evidence earlier to indicate that there was a significant increase in crime. I think it might have been Mr Quinn, that Australia is becoming very attractive to criminals, and that in addition to the practical impact in the community, that this could lead us to being grey listed by FATF. Do you have a view about either of those matters?
Oh, look, this is a very scary proposition, and with the submissions coming from other law enforcement agencies, whether it be AUSTRAC or the Australian Federal Police, these are the fears, and this is why we're really strong behind this legislation. It's about making sure that we stop problems before they start. Again, we are playing catch up, but with these huge issues, Australia at the present moment, and especially when we start to open up to the world again, we have a huge drug market. The markup of drugs here is higher than anywhere else. There's that profit margin that's extremely great. In regards to opportunities that are going to occur over the next couple of years, there's heaps of areas where ill-gotten gains can be invested and then laundered as such, and then that money goes back overseas. There's heaps of investment, there's heaps of issues that are ongoing. That's why we need these gatekeepers of professions that actually are meant to monitor in regards to the proper legality of purchases, companies, trusts. They actually need to be accountable as well. And that's first is with the information flow, the mandatory reporting, and then the next follow-up is obviously punitive measures or measures that actually reduce their capabilities of actually laundering that money as well.
So just to be clear, I'm going to ask you a couple of really straight questions, and you've traversed this area somewhat, but exactly how would implementation of Tranche 2 reforms aid law enforcement agencies in Australia in detecting, apprehending and prosecuting criminals, both domestic and foreign?
Well, increasing the threshold and actually making more rules around it makes it more transparent. Therefore, and the reporting mechanisms we would find, and especially from organisations that are playing by the rules, we'd say, oh, hang on a minute, well, this is the statistical data that's coming back. An organisation of this size, or a law firm or a real estate agent of this size, with this much turnover, technically they should be reporting maybe 5 or 10 incidents a year. Then we'd be able to look at other organisations that are of that similar size, that similar nature, and hang on, they've never reported anything at all. Why is that? It could draw our attention to that, and then we would look at our other databases, look at our other resources, and it's also about exchanging of information. Intelligence is so important, and I know you've discussed this many times on this committee before, but with that intelligence leads us down a direction where we can actually start to investigate, and then we start to put those pieces together. So with this legislation, because again, it ties it up in that bureaucracy, it ties it up in terms that average police officer or a person that thinks it's not right would look at the legal documents and go, well, it must be. It's been done by a lawyer. It's been done by a real estate agent. The accountants have oversight it. It has to be legit. When we have those checks and balances and they actually do have to report, I think that gives us a good litmus test to actually then progress forward with those organisations that are not going to abide by the rule regardless of what law we put in place.
What are the implications for Australia's international law enforcement reputation if we have another 3 years of failure by the government to implement Tranche 2?
Look, our members want this now. We want this legislation in place because, as I said before, we're playing catch up. This is something that is world standard. It should be best practice for Australia, and we are a leading law enforcement agency across the world. But in saying that, this is where we're dropping the ball. I think the AFP, especially with their international contacts, could probably answer that question better than myself. But again, when we speak overseas, Australia is a guiding light for nearly all law enforcement. But I think it boggles my colleagues' minds that we do not do this.
So we've got an intelligence gap because of the failure of the government to implement Tranche 2.
Look, I think we can see it. I mean, we just talked about the numbers. It's $50 billion a year. We're just seeing inquiry after inquiry. We've seen the casinos. We're seeing corruption issues popping up. I think everyone knows about incidents or stories, and we see the drug trade coming here. We need to put these measures in place to start being preventative and actually stop these problems before they start, because all it's going to do is build up more momentum and cause more issues for Australia and the community.
In your submission, you've called for increased legislative tools we've discussed to combat organised crime and to give you back your capacity to be on a level playing field internationally with your compatriots in other countries. What would those tools look like, and would they be assisted by more resources for AUSTRAC? Is it law? Is it physical resources? Public education, changes to gambling law? What actually needs to happen? And I'm happy to take evidence from both of you.
I think resourcing is one of the key issues. I think if the designated non-financial businesses and practices were brought in under the AML-CTF Act, we would see an increase of a regulated population of 16,200-ish to add another 160,000, I think is what the AUSTRAC submission stated. That's going to require something like a 10-fold increase in resources for AUSTRAC. So yes, resourcing is definitely a key issue. I think there's also resourcing issues within the Australian Federal Police for the sorts of prosecution of money laundering matters. And I think there's also perhaps a cultural shift that might be worth examining inside AUSTRAC. So the move from the apparent failure to detect 23 million international funds transfers over a 5-year period, equating to $11 billion in Westpac, equates inside AUSTRAC perhaps to a process that isn't capable within AUSTRAC of detecting non-compliance within regulated entities already, and if you add another 160,000, perhaps a lower level of capacity of detection of non-compliance. So yes, resourcing, but also cultural shift, I think, or perhaps carving off that regulatory function from AUSTRAC and give it to a body dedicated to the regulation of and enforcement of anti-money laundering and counter-terrorist financing regulation and law.
Can I just come in on Senator Neill's point? I just want to focus on this issue about responsibility. Professor Fels made some comments recently following matters in regard to some of the casino questions, and both of you referred to that. You referred to the $50 billion scale of the problem. You referred to the banks. You know, the two banks, the Westpac and the Commonwealth Bank, are both involved in quite substantial penalties being. So there is clearly a major difficulty here in the regulatory area. So what Professor Fels said is this. Now, of course, behind every regulator's failure is a lack of backup from government. Typically, regulatory failure is not just a regulator not doing its job. Sometimes that happens, but usually the regulatory scheme is not that strong. There are other action signs and signals from governments, and it applies all around Australia. They don't give them adequate budget, proper powers to investigate, inadequate sanctions, and what we are getting at explicit and implicit signals to regulators not to go in too hard. Now, that was a statement he made recently on the ABC on the 28th of October. Could you respond to that proposition?
Look, again, with these, sometimes it's probably the best scenario that I can do just to the police officer out on the street is probably illicit tobacco. We know where it is. We know it's there. We know it's against the law. But in regards to resourcing, police officers have numerous other jobs to go to. But on top of that, too, they actually don't know what the legislation, the capability and how to enact it. The education, the training there, unless it's been special officers, is not there. And again, when we talk about resourcing with AUSTRAC, the size of the problem is just so vast. So the Federal Police, AUSTRAC actually need more basis for that like for...
Yes. So, Mr Webber, I want to get to the... I'm not asserting that this is a problem for the Federal Police per se. I'm saying it's on that assertion by one of our leading regulators in the past, in terms of Professor Alan Fels. He's saying that this is a problem of government, of governments. I don't want to make it a party political question, but of governments, sending a signal implicitly or explicitly that this is not the priority. What do you say to that proposition?
Totally agree, yes. It's not the priority because the legislation hasn't been done. We're lagging behind the rest of the world and we're playing catch up. We know where the best practice is and it's been highlighted so many times to governments before in the past. Yes, totally agree in regards to that, and that's why we're sitting here today extremely supportive and want this legislation done sooner than later.
So, for instance, this morning we've received a letter from the Russian ambassador who tells us that he's disappointed with the lack of interest and engagement on part of Australian colleagues. This is in regard to money laundering and other such matters. Suffice to mention that there has been no AML or CTF related requests coming for Australia for the last 3 years. Does that not tell you something about the level of political priority rather than, as I say, I'm not seeking to blame the AFP in this matter or the agencies themselves, the lack of political priority emerging around these questions?
Well, look, I have no knowledge of that, but that does boggle my mind. Why wouldn't you speak to that country? And not to cast any dispersions on Russia at all, but that's from the ambassador himself. You would think that Australia would be asking those questions quite regularly in regards to those issues.
And we've got one here from the Chinese government that's saying that, in terms of their interests, similar types of, commentaries being made. They're only in charge of investigation under Chinese jurisdiction, have little knowledge of the adequacy and efficacy of Australia's anti-money regime. As the evidence that crime proceeds in Australia and real estate and other markets, Chinese law enforcement agencies have already provided to Australian accountants request information when investigations is launched. I mean, there's a suggestion, as I read that we're waiting. What about it? You know, so is there a problem here at our end in terms of seeking to actually take these matters up?
Look, I think they're questions for the AFP because
Yeah,
I think probably there might be some issues in regards to protocols, policies, procedures, or also the exchange of information and
Yes, I accept
security of that.
I can ask you these questions because they might be bound by other protocols about what they tell
Yes.
us in a public forum. You know, other than have stuff in camera, but it's. And you're not bound by those protocols, are you? In
No,
terms
not
of
at all.
your capacity to actually speak freely about the lack of political priority on these issues. And I emphasise this is across the board. These are not problems confined to one particular regime. These are a number of issues because you've raised a number of financial institutions, a number of instances in your presentation here today. But it comes down to this fact that regulators operate within a political environment, don't they?
Yes, they do.
Is that a fair assumption to make?
Fair assessment, and what we do is we want people to back us so we can do our job. And it's extremely important, again, that we stop playing catch up, that we get best practice, and then we become a leader in regards to this, because this is an issue
That's right. And at a national level, this is clearly a responsibility in this parliament for the Commonwealth Government.
Yes, and the advantage of the Commonwealth doing it and federal legislation is that you harmonise all the laws. We're all playing, and those organised crimes where it used to jump across the borders, and we've had this conversation before with this committee, that the harmonisation of unexplained wealth is extremely powerful because then we can start to confiscate the assets. And it comes back to your question before about resourcing as well, is that once we actually know where the problem is and we confiscate those assets, then those assets can be utilised to actually fund more of AUSTRAC, fund more of these operations, and it just has that ongoing effect where we can actually start to put those funds, those ill-gotten gains, those funds back into actually stopping more of it occurring, and that's a really good way to fund.
Thank you, Mr Webber. Sorry.
Just a couple more if I can, Chair. Thank you. So there's also a dissuasive effect of people seeing that occurring to other people who they thought were above and beyond the law. So if I can just go to the practical reality of a government ignoring international requests from FATF is that the proceeds of criminal acts such as child exploitation, people smuggling and organ trafficking are actually being laundered in Australia. So the scale is quite large. Mr Chevis, I've already quoted you talking about the Bergen report. My question goes to you. Given the impact of that on real lives, do you support reforms that would increase the personal liability of directors and officers found to have engaged in material non-compliance with AML-CTF breaches? And do you think that would be sufficient incentive for directors and company officers to further tighten their internal compliance with AML-CTF for the banks, as well as other corporate entities, as well as those who are proposed to be brought in as DNFBs?
Yes, I do. I think bringing in personal liability for breaches of the AML-CTF Act would sharpen the focus inside the entities covered by the AML-CTF Act. Although there's a whole range of money laundering that occurs outside of the entities that are currently regulated, so we would need to consider, if you were hoping to achieve actual effectiveness, you would need to consider all of the other methods of money laundering that we currently know about that don't necessarily use the reporting entities currently covered. I also think, as I mentioned before, that application of the criminal code and prosecution for money laundering may sharpen that focus as well, particularly if we can increase the penalties for corporations and also make it easier to prosecute people within entities for money laundering, because that would cover all of the other entities that aren't currently covered by the AML-CTF Act and may never be covered by the AML-CTF Act. So not just DNFBPs, but dealers of high-value goods, import-export companies, people involved in running nightclubs and bars and tattoo parlours and all of the cash-intensive businesses. There's a whole range of other ways to money launder, outside of the area that is currently covered by the AML-CTF Act. And in fact, it appears that because of the increase in the other methods, as people learn methods of circumventing the laws, the areas that are covered will become decreasingly relevant. So yes, I support the application of personal liability, but we also need to look at charging people with money laundering and charging companies and entities with money laundering as well.
Okay, so we're looking at, in particular, FATF and AML and CTF, but you're indicating that there is an additional body of work that needs to be done in other legislation that we should anticipate.
Yep.
If Tranche 2 is actually brought to bear, that there will be a reaction to that and a diversion to perhaps less efficient but nonetheless dangerous methods of money laundering that could grow at scale.
Well, effective methods. Whether they're dangerous or not, I wouldn't have an opinion on, but they will be more effective methods. They may be, as you say, more expensive, less efficient for the launderer, but we already know that money laundering occurs by the movement of goods. So the value is not going through the banks or any other entity, for example. It's just movement of goods across borders to pay for drugs.
Are you aware, Mr. Chervis, of the concept of being grey listed?
Yes, I am.
Okay, so could you explain what the impact on the Australian economy, industry and business would be if Australia were placed on the Financial Action Task Force grey list? And one of the consequences, I understand, would be increased monitoring. What would that do to the cost of international business?
Well, one of the impacts is supposed to be increased monitoring, but that monitoring would occur in other countries, and to have an impact on the Australian economy, it would have to occur in our major trading partners, and it would have to occur within the banks in those major trading partners. Now, as we've seen across the world, banks can be swayed to ignore these sorts of directives, and so I have a suspicion that if Australia were placed on the grey list, and I have a suspicion that it's highly unlikely that Australia is going to be placed on the grey list based on the countries that have been placed on the grey list in the past, if we were, I'm not sure it would have much of an impact at all. And I know that's contrary to many of the opinions you'll hear here, but it's because of my understanding of how banks typically engage in things like enhanced customer due diligence. And where you have, say, Rio Tinto or BHP exporting iron ore, the Chinese banks that are dealing with the payment are unlikely to apply enhanced due diligence to those sorts of large exports. So I'm not sure it's going to have much of an impact at all, and I don't think it's very likely that Australia will be placed on the grey list.
Even if the government continues to do nothing about Tranche 2, I mean, we're years and years behind.
Yeah, sadly, and that's because of the way the FATF functions.
Interesting.
I can make further submissions on that if you'd like.
Yeah, we might have some questions on notice. Can I just ask final question, if I may, Chair? What can Australia learn from the experience of other jurisdictions, such as the UK and New Zealand, in the implementation of Tranche 2? And if you have anything to say about Turkey, and the grey listing there, that might be of interest too.
I don't have a lot to say on Turkey at all, except to note that its GDP is half of Australia's, and it's not we're the 13th biggest economy in the world. The FATF doesn't really come near large economies, and the prime examples of where the FATF hasn't done work is in all of the money laundering and tax havens. You know, we've got Delaware, South Dakota, Florida, Luxembourg, Liechtenstein, Switzerland, Cayman Islands, Panama. Most of them have never been touched by the FATF. And this is the reason I suspect we're not going to get grey listed. Sorry, did that answer?
Well, I think Senator Carr's just indicating New Guinea, Papua New Guinea. What's the situation there?
I do quite a lot of work with Papua New Guinea and have done for many years.
So could you give us an indication of what you believe the current situation is with Papua New Guinea?
In relation to anti-money laundering?
Yeah.
I think that, like many countries, many developing countries, they have significant challenges. Like many developing countries, they are required in many ways to to apply a greater level of resources to compliance with FATF recommendations than, say, Australia would have to, a greater comparative level of resources, but that they are moving ahead, and they've done quite well. They were on the grey list, and they enacted the laws and got themselves off the grey list. So I think they're on a good track.
Thank you. So, Senator McKim, you've been waiting patiently. Would you have anything further to add?
I would. Thanks, Chair, and good morning, folks. Thanks for your attendance this morning. Mr Chevis, if I might start with you, please. You've previously said that everyone in the world who is involved in AML-CTF knows that lawyers, real estate agents and accountants are well used by people who have illicit wealth to transfer. Do you stand by that statement?
Yeah, I do. Yeah, all of those methods are well known amongst the sort of the anti-money laundering circles, but I also suspect among people who have money to launder. Yeah,
thank you. And would you agree with the proposition that we've heard from other witnesses this morning that Australia's failure to legislate for the gatekeepers for Tranche 2 in our AML-CTF laws makes us, a consequence of that is that we are more attractive for people who want to launder money on a global scale?
Well, certainly our failure to address money laundering through those areas has made us more attractive. But how we go about reducing the attractiveness of those areas, I think, should be up for considerable debate. If we don't bring in Tranche 2, then I think we need to look very carefully at the prosecution of those entities for money laundering, and also the prosecution of people within those entities for money laundering, in order to achieve perhaps a similar or the same result as would be achieved if we brought Tranche 2 in.
All right, thank you, I understand that. But just for clarity, would, in your view, legislating for Tranche 2 reduce Australia's attractiveness to money launderers?
On the face value, it would, but I think what should follow is a national risk assessment process or something similar, and an evaluation of the effectiveness of the measures put in place.
And you would argue that that should happen subsequent to legislating for Tranche 2, is that right?
Ideally beforehand, so we have a baseline of the sorts of money laundering seen through those areas, and then a measure of the reduction, or at least an estimate of the reduction achieved through whatever measures we put in place.
All right, thank you. AUSTRAC relatively recently released money laundering and terrorism financing risk assessment in regards to major banks, and they found that one of the consequences of breaches of AML-CTF controls include widespread or concentrated real estate purchases with the proceeds of crime, which are driving property prices up and pricing legitimate buyers out of the market. Would you agree with AUSTRAC?
I don't know that there's any effective way of measuring the impact on the price of real estate based on the laundering of proceeds. Certainly there's anecdotal evidence to say that occurs, but there's no really hard and fast evidence to say at what level it occurs and what impact that has on real estate pricing in Australia. But on the face of it, it is very attractive to assume that because real estate is a money laundering methodology, that it is pushing up the price. And certainly, intuitively, it would appear to be the case. But we don't necessarily have the evidence to really understand at what level the impact is.
All right, thanks. Could you, based on your experience, explain the mechanics of how somebody might actually go about laundering money through real estate? Like what role would a lawyer or an accountant or a real estate agent play? How would money come into the country if it was money from another jurisdiction that people were laundering, and how are the transactions disguised?
The methods and processes are probably too numerous to discuss in this sort of forum. But we know that there are a multitude of ways of getting illicit funds into Australia. You can move assets into Australia. You can move money through casino accounts. You can move it through real estate and law firm trust accounts. You can move it through Hawala dealers and underground banking. The list really goes on for how you get the money into Australia. How you then go about purchasing property is again in a multitude of ways, and one of the key ways that I've seen in not so long ago was the use of an Australian private company registered in a fake name to purchase property that was then not linked to the offender. So there really is a multitude of ways that it can be achieved.
And is it pretty easy if you've got the money behind you? Would you describe it as a relatively easy thing to do?
I've never tried it myself, but sorry, that was a bit flippant. It would appear from the volume of real estate.
No room for humour here, you know.
No, sorry. It would appear from the volume of real estate owned by politically exposed persons from foreign jurisdictions that it is too easy, I think, would be the underlying takeaway from that.
All right, thank you. And would it be less easy or more difficult if Tranche 2 were legislated?
One would hope so, but again, without looking at what actually occurs within the entities that are being regulated, we won't really know. So, for example, they'll be asked to submit suspicious transaction reports or suspicious matter reports, as they're known in Australia. We know that law firms in particular and lawyers as individuals are rather reluctant to report suspicious matters across the world. And we can't know whether law firms and even real estate agents and accounting firms are going to react and start reporting suspicious matters as we perhaps would like them to. We also know from things like Westpac and Commonwealth Bank that entities can be sometimes, if not reluctant, they're not very good at reporting threshold transactions. So again, we don't know whether they will report them. And when it comes down to things like know your customer or customer due diligence, we don't know how well they'll do it. So we don't know whether we'll have an actual impact on crime or, in this case, an actual impact on money laundered into Australia from overseas.
All right, thanks, Mr. Cheverton. Thanks, Chair.
Thank you very much, and thank you both very much for your appearance today. I take it before we depart that there are no other questions? No other senators has any questions? We're all good?
No.
Thank you very much indeed.
Thank you, Chair. Thank you, Senators.
If there are questions on notice,
Yes,
I think
may
you've
be.
agreed to take some modest requests. Thank you very much. And I would now suspend the committee for morning tea until 11:15. Is that right? I welcome Dr. John Coyne of the Australian Strategic Policy Institute via video conference. Dr. Coyne, I thank you very much for taking the time to give evidence today.
Thank you, Chair.
I take it that information on parliamentary privilege has been provided to you?
Yes, it has, Chair.
That's right, very good. And if you need any further information, it's available from the Secretariat. The committee has received your submission at submission number 10. Do you wish to make any corrections or any additions to your submission?
No, I do not. Thanks, Chair.
So for the Hansard record, would you please state your full name and the capacity in which you appear today?
My name is Dr. John Coyne, and I'm head of the Australian Strategic Policy Institute's Strategic Policing and Law Enforcement Program.
Thank you. Would you like to make a brief opening statement before we go to questions?
Yes, I would, if that's okay. Thank you,
Yes,
Chair.
of course.
Look, first and foremost, I want to acknowledge the hard work of Australia's law enforcement agencies and their personnel working on anti-money laundering and counter-terrorism financing, as well as their broader fight against transnational serious and organised crime. And I want to recognise their commitments and achievements, which are both commendable. With that in mind, I do want to sort of sit there and provide the Chair with really just a brief overview, which is the AML provisions really, as you well know, exist for three reasons, or certainly the regime itself. The first one is to focus on regulatory compliance and enforcement. The second is to attempt to support law enforcement through the collection of criminal intelligence and evidence. And finally, it's concerned with reducing Australia's vulnerability to transnational serious organised crime. And as I highlighted this state, my following comments are not a criticism of law enforcement, but a criticism of the strategy, which is, put simply, earlier this year, a colleague of mine, Dr. Tegan Westendorf, and I undertook a detailed study of the methamphetamine and heroin trade in Australia. And out of that report, to put it simply, some $1.2 billion of value needs to be transferred from Australia to out into the world to pay for drugs. Just those two types of drugs. The figures that we got from that come from our outstanding work, as in the Australian government's outstanding work, I should say, in terms of wastewater analysis, which is how much, and gives a really quite clear estimation of how much in terms of methamphetamine and heroin we consume in this country. So one can only draw the conclusion that with over $1.2 billion of money heading offshore at least to pay for those drugs, and a total consumer market for just those two drug groups of some $6.7 billion, the anti-money laundering regime in its current format is not impacting on significantly on money laundering in this country and from this country. The second point I make with that is that quite often the argument or counter-argument here is that, well, things could always be worse. But I go back to the 3 points of why the AML regime exists, and none of those 3 reports or 3 points are really about preventing the situation from getting worse. So with that in mind, I put to you that there does need to be significant deliberations given to updating and upgrading our AML regimes. And if the committee were to take 2 points forward on that, I would say this. The first one would be that we need to introduce the Tranche 2 provisions, and they will be pivotal in dealing with this challenge. Secondly, is that we need to get far more innovative in this space and move away from a tendency of over-regulating towards a more innovative and agile approach to money laundering, counter-terrorism financing and transnational organised crime in this country. Thank you, Chair.
Well, thank you. So you say we should be more innovative rather than over-regulating. Perhaps you could give us an indication of what you mean by innovative rather than over-regulating.
Of course, Chair. Look, thank you very much. I think one of the issues that we have is, let's take the finance sector here. So the focus on finance sector compliance with the AML provisions is really about about compliance with the laws as they're written. Now, for a financial institution to invest in more innovative approaches, so the development of self-learning algorithms, etc., that by no means accounts in any way to their compliance. So in terms of the cost, it's an additional cost on top of compliance with the existing regulation. Secondly, is that whilst regulation and compliance are critical, the transfer of intelligence from the public to the private sector, especially in terms of the finance sector, is critical in proactively identifying cases of anti-money laundering. So by this, I mean everything from modus operandi through to detailed algorithms on sets of behaviour to be able to identify money laundering behaviours.
For my sins, I've been placed on a number of scrutiny committees in this Parliament, the regulations and the Scrutiny and Bills Committee. And there's a number of principles that those committees do examine in the way in which legislation's written. And there's reluctance amongst parliamentary draftspeople to write laws which don't provide a clear guidance to regulators as to what they're enforcing. What I thought you were saying to us, and perhaps you could then enlarge on this, so in case I've misunderstood you, there is that there should be a broader scope for discretion in the way in which regulations are enforced. That is, to keep pace with changes and the like. I mean, I know the argument, but it does present if that is the case, the proposition you're putting to us.
That is the case, Chair.
Yes, it does present quite a serious problem in terms of the normal provision of concerns on liberties that citizens have a right to expect in terms of any legal enforcement, to know what it is that the law says, and for regulators to know what it is that they're being asked to enforce. What do you say to that proposition? How do we actually get that balance right between trying to keep pace with technological change and changing patterns of or cultural change, and the need for clear guidance as to what the law actually says and what would minimise the level of discretion, which in the wrong hands can be grossly abusive?
Look, Chair, I absolutely agree with you in terms of discretionary power. First off, in the potential for abuse, and certainly on several occasions I'm on the public record and writing of my concerns around that, around law enforcement powers, etc. Especially we see this play out in the current environment with extraordinary powers in relation to policing and COVID-19. I by no means am I presenting you a simplistic, this is the answer and that there isn't a significant problems and challenges to that. I think first off, what I am saying to you is that what are the alternatives? Because a strictly regulatory prescriptive approach, it's several steps behind in terms of being able to deal with the challenge of money laundering as well as other criminal activities. Secondly, is that this is an approach that's been taken in other areas where we've seen a far more, and by this, the one area that comes to mind is in relation to the government's role in security. So moving from a very prescriptive model in terms of protective security to a far more principle-based model, and how that can be operated. It is not without challenges, and by no means am I trying to argue that it's an easy pace forward, but I'm not convinced there's any other way. If indeed, when we go back to those numbers, which is right about now, just from the last 12 months, just from the consumption of methamphetamine and heroin in this country, there's roughly about $5 billion floating around in our economy somewhere that comes from just that part of the criminal world. So, and I take your point, I think that privacy is a critical component of this. We're not asking, we're not asking this to be prescribed, or I'm not asking anything specifically to be prescribed, but certainly there is a great deal of ways in applying modern technology and implying artificial intelligence where an individual's privacy will not be compromised, except when a case itself is examined.
You see, and the obvious comparison is to say, well, what is the world's best practice? Internationally, how do we compare? And the evidence put before the committee is that we are falling further and further behind. Now, the leading countries in this field, and we've said the United States and the United Kingdom, for instance, which we like to compare ourselves on many other things, do have a reputation for the maintenance of a balanced approach in terms of civil liberties and protection of the public from organised crime. Would you agree?
I would agree with that, Chair, yes.
They would claim that. Now, I mean, there's a big argument. American Civil Liberties Union may not share that view, but I'm saying that is clearly the balance that we've got to find somewhere in this argument. Now, they don't rely, do they? Those jurisdictions don't rely on discretionary powers of regulators to pick and choose. And you mentioned the security area. There's grave concerns about the misuse of security powers in regard to human rights and civil liberties emerging in that field.
I'm particularly speaking on the security side, Chair, in regards to protective security and protective security requirements, and I don't think that would be a criticism of that. Where I'm talking about that is, for instance, if you were to look at the principle-based approach that's applied to the security of public places, not necessarily security law in terms of surveillance. I think they're two very separate things, and I would be quick to add, and again, that I'm on the public record with regular publications around this about the dangers of overreach in terms of surveillance and those national security powers. Secondly, though, I still think, though, that, the issue here isn't providing, and, it's not a binary discussion of do they have discretionary powers to go on fishing trips or do they have no powers? No, do they have to specifically apply to prescriptive law? What I'm saying here is that if a financial institution, a major bank, decided to apply a new technique for data mining its transactions and was willing to invest a significant amount of money in that to identify transactions that could be suspected of being involved in money laundering, should that be offset by the costs of other implementation, other compliance issues? And that's where I'm sort of looking at, which is, would we have that sort of flexibility? And I think that's where some of the flexibility needs to come in the system.
Okay, so can I come back to my specific point, though? When you compare to the way in which the United States or the United Kingdom operates in this field, what would you say we could learn from them in that regard?
Look, I think that we could learn from both the US and the UK in terms of the sharing of intelligence between the private and public sector, and the flow of information in regards to criminal activity. I think that that is particularly important, but I think that we also need to look at it in context. I'm not so convinced that their regimes, they are better practice than what we've possibly got, but I'm not necessarily agreeing that we should be looking at them going, well, that we should be imitating their approaches. I think a far more innovative approach needs to be taken into this country.
Thank you. Senator O'Neill?
Yes, thank you very much, Chair. So if I can pick up the threads of what you've been saying there, Dr. Coyne, and thank you for your work in this area. You're urging us to just do the job, get Tranche 2. You say it's pivotal. There's certainly been delay. All the evidence this morning has been that Australia really is a recalcitrant in terms of international citizenship here. Yet you're saying perhaps there is a silver lining in terms of technology shifts that have occurred in the interim that might allow Australia to implement an even more efficient and effective model of Tranche 2 if we were able to access the benefits of private sector R&D.
Look, to some extent, I think that regardless, Tranche 2 needs to be implemented. I just can't see how else we can move forward. There can be no doubt, and it's not anecdotal evidence, it's clear qualitative and quantitative evidence to indicate that those who would be covered by Tranche 2, there are elements there that are directly involved in money laundering and transnational serious organised crime. And I think the evidence speaks for itself.
And can you name those sectors clearly for us, Dr. Coyne?
I would say right from the start, the top: accountants, the legal profession, and real estate. And I think that something needs to be done.
Okay, and in terms of, I always try to translate what happens here in the Parliament to a normal conversation that's happening amongst Australians. Australians hold accountants, the legal profession, and perhaps a little bit less so real estate agents, in considerably high esteem as professionals with a degree of expertise and long training and ethical requirements and oversight bodies that look after them. Why should Australians care about whether the government implements Tranche 2 or not? What's in it for Australians if the government continue to not act, or if the government does act?
In terms of two drug types alone, it means more than $1.2 billion moving offshore to pay off the wholesale prices for illicit drugs. It means $5 billion plus floating around our economy. That money's being laundered somewhere within the system, and what we're talking about Tranche 2 is a positive step forward to dealing with that. I agree with you in terms of, and it is quite interesting from a cultural phenomenon sense, those professions have long been trusted, regardless of today, your comment about real estate, they've been long trusted in our communities. over multiple generations and been entrusted to self-regulate for a range of reasons. As professions, I suspect that now we're seeing sufficient enough evidence globally and nationally to say that that needs to change. But my other point is that we need to encourage a type of thinking within the finance sector that says that not just about complying with the letter of the law, but going those extra steps and being far more proactive about dealing with anti-money laundering. Now, some of those financial organisations within the finance sector are already doing so. So, we're seeing banks being very proactively about shutting down accounts, as an example. So there are some really positive examples there, but what I want to do is try to supercharge that, or I'd like to see the committee supercharge that proactivity and find a way in terms of legislation to encourage that.
Okay, thank you. If I could just step through some practical things that you might be able to put on the record that people don't know. So you talk about the enormous profit of the illicit drug trade. You've indicated 1.2 going offshore of a 6.7 billion trade in methamphetamine and heroin. From previous witnesses, we've heard the scale per annum of this sort of practice is sitting at about 47 to 50 billion per annum across the nation. How are profits being washed? And what is the proportion of profits being washed in Australia by comparison to other jurisdictions, even in the Asia-Pacific region?
Look, it's incredibly hard. So the figure you gave of $47 billion, I believe, is an estimation of the total cost of transnational serious organised crime in this country, which is inclusive of law enforcement efforts and a range of other money that goes into that. I think in terms of it, and I was having a conversation before giving evidence this morning and to a few colleagues from my previous employment at various stages, and we're talking about, and I think it's very easy to want to have binary or draw binary statements around organised crime. So it's being money laundered through hard cash, or it's being money laundered through banks, sort of thing. What I suspect is an incredible amount of money is done through trade-based money schemes. Because just the volume of money we're talking about. But, we're still seeing, up until COVID came along, for the committee, we were still seeing cash being moved from the West Coast to the East Coast in terms of the drug trade via aircraft. So, it's all of those things, and this is part of the challenge. And I think the other part about this for the committee to consider is that organised crime itself, I'd like to describe it as amorphous. What we've seen is since the 1960s, and through popular culture over the last 2 decades, is we have this conception of organised crime as a hierarchical structure where there's a boss, a capo, a lieutenant, a captain, and that structure's all underneath. In reality, those structures do exist, but in reality, transnational serious organised crime has a tendency of being amorphous. It fits and identifies opportunities and rapidly exploits them. So from that perspective, and I'm not saying everything is used for money laundering. I wish I could give you a percentage saying, 10% is done by this means or other means. What I'm saying to you, though, is that a significant amount of the money laundered out of this country must be involved in trade-based money laundering because of the numbers involved.
Okay, so for a non-literate person, what does trade-based money laundering look like? Because I've got a feeling this could be happening in everybody's backyard.
Look, if people want to think, there's a variety of ways and structures to this, and there'll be people appearing before you who are far more qualified to talk about the latest methods of doing so. But this goes through everything from, transferring other products in kind. So we actually saw this, in an illegal sense, we saw this a number of years ago, which is Mexican cartels moving cocaine to Hong Kong, swapping it for methamphetamine on a trades basis and sending it back. So no money ever transferred hands. What they were doing is they were transferring drugs for drugs, as an example. Value for value. So if you think about it, there's things like international transfers in terms of purchasing goods that are never actually delivered. Those sorts of transfers between companies, the use of second and third party companies to transfer value for purchasing goods, the contamination of supply chains, those sorts of activities. So it's a very broad church, but it's more than just sending for the average person in Australia. It's more than just transferring in a bank account or an international transfer or a hard currency or a online credit card. It's far more complex and uses the complex nature of our supply chains and business structures to hide that activity.
So we see that banks have been doing an awful lot of the heavy lifting in this area, and they are making investments to make sure that they're complying. Yet we've heard evidence this morning that there need to be civil penalties for CEOs and board members to really harness their focus on taking these AML and CTF laws seriously. What are your thoughts about civil penalties and corporations?
Look, I think in my dealings with this, I'm of two minds of it. First off, I'm not convinced in a general sense that the stick is always the greatest motivator for people. I have the conversation, even if someone was going to do the wrong thing, and here I'm talking about, I'll use the general issue of organised crime as an example. Of all the offenders I've spoken to, and when I speak to colleagues about their experience, no offender starts off in their life going, I think I'll get caught. So that's at the extreme end. So I just don't think it's as strong a motivator as people are inclined to believe, that the stick hanging over someone's shoulder is going to make them comply. Secondly, I think that what we want here is that if there's a degree of criminality or of general act of commission or omission that has led to an AML issue, I think that they should be held accountable for that. But there's a lot of very grey zones in between those two areas, between that and not knowing. So I also put it to you that in terms of the AML legislation, I think that we're far better off getting the financial sector on board to be more proactive in terms of working. We've seen the beginnings of this in AUSTRAC with the private and public sector working together. I would think that we would be far better at putting greater efforts into getting that collaboration than introducing more sticks and regulation.
Okay. In your special report into technology that you wrote in July 2018, you talk quite a bit about this public law enforcement, lack of funding, investment, R&D by comparison to the private sector. Do you think that AUSTRAC's kept up with the increased use of technology by criminals?
Look, I think it's struggling. You'll always find. I think you'll always find a gap between emerging technologies. Criminals have become really adept, as have our children, for that matter, in early adoption of new technologies. It takes organisations and bureaucracies a lot longer to develop them. Unfortunately, there's a couple of factors and strikes against organisations like AUSTRAC in the law enforcement space. Number one is the overarching demand for acting in the now. So it's not like there's a whole heap of spare capacity within, say, the Australian Federal Police or AUSTRAC that's sitting there not being exercised right now, or that can be focused on the future. The demands of the now are so intense, and I always put it this way, the amount of reported crime, and this goes for AML as well, far exceeds the capacity of law enforcement in this country to respond.
And that's before we bring in tranche 2.
That's correct. So I guess my point here is that, it's very hard for them to be in the front foot there. Secondly, is that the nature of the bureaucracies is that we hold them to account. So successful organisations in R&D and technology, so if we look to Google or Apple, are successful because of their failures, not in despite of them. So when you're talking about R&D, and in terms of our public institutions, of course, we have very low tolerance for them failing in an initiative. So as a result of that, being innovative and cutting edge and agile is incredibly difficult for our law enforcement agencies. So there is a gap between those. I'd like to see that gap close. And I note that your comment about tranche 2. I think this is where, regardless, I think there's some great value and low-hanging fruit in the early implementation of tranche 2. And it may actually require a readjustment of priorities within AUSTRAC as a result of its implementation. But certainly, and it's the luxury of working in a think tank, which is, of course, I'm going to say, that should be funded with more money. And the challenge for you is, as a legislator, and the challenge for the people in bureaucracy is that there's no extra money sitting around. So I'm well aware of that as well.
There's a bit of extra money sitting out there that we're not looking at, though. 50 billion.
That could be the case.
Yeah.
That could be the case.
In the same report that I just referred to, I can see clearly now, you recommend that AUSTRAC establish a regulatory sandbox to explore new policies of the kind that you've just been talking about and offsets for those companies that contribute to AML efforts. That's kind of the innovative regulatory approach that you were talking about earlier with Senator Carr. Has any progress been made with regard to that recommendation from you about a regulatory sandbox?
Look, there's been some progress in terms, there is a greater cooperation between AUSTRAC and the finance sector, and there's an incredible amount of goodwill. But if you're asking the question directly as you put it, I don't see evidence that that's the case, and I think that we need to get smarter in that space.
Mr. Scott Webber gave evidence earlier this morning about the impact of bringing in accountants, legal and real estate, citing property being sold through different real estate agents in the same market where there might be 5%, look like there are, shady dealings, would trigger a response where there were no reported shady dealings by another competitor, and that would help them get some surveillance over the sector. That's a practical way that bringing this legislation forward in Tranche 2 would operate. And that would actually give the police some capacity then to interact with their international comrades about matters. Could you respond to my concern that in the absence of being able to gather intelligence, the AFP, AUSTRAC and regulatory bodies in Australia don't have information tradability in the international context, and they're relying on incoming intel. For example, the cocaine that was being laundered, intel came from overseas to AUSTRAC for that, didn't it? So can you talk about that ecosystem for me?
Look, sure. I guess there's multiple parts, and I think there's no point. I'm going to say that when I first was trained in intelligence some almost 3 decades ago, it was said to me, intelligence isn't self-licking ice cream. In the sense that, you don't just collect it for the purposes of collecting it. You collect it to do something with it. Now, the first part of your question is in relation to, it would be great to have this additional intelligence if in fact you are able to process it, gain meaning from it and use it in a meaningful sense. And I think that's the number one problem. So that will mean new capabilities are required. Now, whether that is new people, or whether that is new analytical capability in terms of artificial intelligence, that's two separate things.
Or both.
Or both, that's right. And generally it is both. I should have added that. Generally it is both, because both are required. But, the challenge we have is that, and it goes to some extent to Senator Carr's comments earlier, and I'm just picking up on his concern again. So it was always difficult. At one stage of my career, I was responsible for releasing intelligence from the Australian Federal Police. And in doing so, I needed to be able to sign off. Generally, there was about 20 or 30 different acts that prevented you from sharing certain intelligence with certain people. So whether an intelligence report that was written by a staff member who had access to AUSTRAC material could only be transferred to only be given to an intelligence agency or only given to a law enforcement agency. So there's all these sorts of control mechanisms so it's not a clear-cut process like this, Senator. It's very much a very complex system in terms of intelligence exchange. There are two formal exchanges in terms of internationally, which is the first one is in terms of what they call police to police, which is police exchanging information and intelligence, but not in an evidentiary form. And then there's the exchange of evidentiary under things like mutual assistance agreements, etc. So, there is this great challenge in terms of offsetting, as Senator Carr said, the requirements and the rightful requirements of privacy, national security, community security, and all of these need to be weighed up. So, it is an incredibly complex system, but as I would often remind my staff in the past, these protections are put in place to be able to protect for very specific reasons. So, for instance, the Privacy Act isn't an impediment to law enforcement. It's a necessary protection in the activities of law enforcement and intelligence.
Could I just ask two related questions? What do you think the impact on Australia's law enforcement reputation would be if the government continued to fail to implement Tranche 2 in terms of reputation, collaboration, and also compare and contrast that really with similar nations to Australia that have successfully implemented Tranche 2? What the outcomes have been?
Senator, look, I think, there can be no doubt that the goodwill in terms of police-to-police cooperation, so these are with our wider allies, and partners won't necessarily, and by that I mean everyone from, the Thai police to the UAE, those police-to-police relations for the exchange of information, intelligence are strong. And robust. The relationships in terms of our more formal agreements with AML are robust. Those where they're in place, and there's many countries where they're not in place. I think the other issue, though, is it's always a nagging thing, which is earlier I mentioned that transnational serious organised crime is amorphous. So what it does, it tends to seek out where the vulnerabilities are. And it's incredibly difficult in a global regime to address AML and CTF if we are the weak link in that. And I think that's the broader issue. And there is some frustration and some, I guess there's some frustration and some confusion within the AML community globally about why we won't implement Tranche 2.
If you could go to the second part, and then I'll come back to your comment there, but where this Tranche...
And can I just follow that? So in your judgment, Doctor, why is it that we won't implement Stage 2?
Look, I wouldn't hazard a guess to put in to understand legislators and policymakers. From my perspective, there is some
Pretty
concern
straightforward,
about how it might be implemented.
We don't initiate legislation. As you know, I'm a Labor senator. We don't initiate legislation. So I think you have to be more specific when you talk about legislators in this regard. Why?
Senator, thank you, Chair. Look, I think there's a general reluctance because of the complexity of the task at hand and its likely economic implications. And I think that it's become, the longer we've left it, the more complex it seems to be. And I think that has concerned a number of those involved. And I think that, there's this sort of hope that the existing regime will work.
The existing regime that other people have implemented, and we sort of ride on the coattails without doing the work ourselves. It makes us sound like a nation of bludgers. That's not a very good image, does it?
Yes, that's... See, I mean, that's... Given ASPI's approach on many other things, I'm just wondering whether or not that's sort of consistent with the normal approach you take. I mean, I've cited this before, so you may have heard this evidence. But Alan Fels, Professor Alan Fels made this observation on the ABC. He says, now, of course, behind every regulator's failure is a lack of backup from government. Typically, regulatory failure is not just a regulator not doing its job, something that happens, but usually, sometimes that happens, but usually the regulatory scheme is not that strong. There are other action signs and signals from government, and it implies all around Australia that they don't give them adequate budget, proper powers to investigate, inadequate sanctions. And that's as typical as it's, they're getting an explicit or an implicit signals to regulators not to go too hard. Is that an explanation that you would concur with?
The first thing I'd say, Senator, is that, look, as you well know, ASPI is an independent policy think tank. Secondly, is that we don't have a corporate position on anything. So certainly I'm engaged by the council here and by the executive director as a senior member of staff. So as a result of that, I'm engaged to provide my opinions. And certainly there is no ASPI opinion on money laundering. And there's very few who deal with that issue in any sense in ASPI other than myself. and my deputy.
Okay, so what, do you think that that's a reasonable explanation for regulatory failure? That Professor,
At
the one
times, I
quote
think-
I've given you?
Yeah, look, Senator, at times I think that's a reasonable expectation. Having said that, though, I think there's always a danger. It answers your own question. There's always danger to present it as either one or the other. I think there's a range of factors in here. For instance, I would turn around and say, as I gave my original evidence, there seems to be some confusion. The role of law enforcement isn't to ensure that things don't get worse. It's to have a market improvement on our community safety. So the KPIs in terms are about of arresting people, seizing drugs and seizing cash. Those are KPIs. The actual aim and strategic intent is making our society safer and reducing the impacts, for example, of drugs on our community. So I do think that times that there are strategic policy issues that relate to regulators, and I think at times your reference is correct.
I'm sure you would be aware of the Prime Minister's recent visit to Europe and participation in the G20. There was a statement, item number 59 in the declaration that was put out following that gathering. And regarding AML, CTF and CPF, it states, we reaffirm our full support for the Financial Action Task Force and the Global Network. And it goes down to say, we confirm our support for strengthening the FATF recommendations to improve beneficial ownership transparency and call on countries to fight money laundering from environmental crime, particularly by acting on the findings of the FATF report. How at odds is that statement, signed off out of Rome, with the reality in Australia today under the leadership of Mr Morrison?
Look, I think that we see that the facts remain is we still haven't implemented Tranche 2. And right to the beginning of my evidence, the situation isn't about stopping things getting worse. The bottom line is the figure that you quoted to me, Senator, which is the cost of organised crime, the last time it was assessed, which was 3 years or 4 years ago, I believe that figure comes from, was $47 billion. I suspect if that assessment was done today, it would be significantly more. And that's the real test. And, to reiterate, I'm not criticising. I think that Senator Carr was touching on this before. I'm not criticising law enforcement. In fact, I led my evidence with a very clear statement about the efforts of law enforcement and commending them on that. I think, though, that more needs to be done.
Well, they can't do more if the government doesn't give them a legislative platform from which to operate, can they?
And I think there's also an issue of resourcing in amongst this as well.
So can I just go to that statement about beneficial ownership and transparency? We've talked about accountants, we've talked about the legal profession, and we've had some evidence about that this morning. With regard to real estate in particular, beneficial ownership transparency is critical. How does Australia compare with other jurisdictions in our region with regard to beneficial ownership transparency?
Look, from my perspective, we are far ahead in terms of the Indo-Pacific region, a term in law enforcement I'm not necessarily particularly comfortable in using, but I think it adequately describes our broader region. I think that there are a number of major challenges in terms of legislation in the Pacific. The same can be said at various locations across the near region in the Asia Pacific, and certainly the same could be said in parts of North Asia.
Okay, and by comparison to best in show, shall I describe it as, the exemplars around the world, the foreign affairs for FATF regulation, how transparent is the ownership of property in Australia?
Look, I think that's a really broad question and a tough one to give an accurate answer in 20 words or less, Senator. But I would say that we've got a way to go in being able to prove beneficial ownership in comparison to, say, the US and the UK and parts of Europe.
Okay. Bringing real estates in under Tranche 2, what will the impact of that be on transparency around ownership in Australia?
Look, it depends. I mean, again, this depends on the legislation that's pushed through, Senator, but I would suggest that it will have some impact. It will enable, and this is one of the concerns of Senator Carr earlier. This would enable, with the right legislation, law enforcement to access that kind of information, to undertake more detailed analysis, and certainly address some of the pervasive feelings of some law enforcement figures over the last 2 or 3 decades around, for instance, the use of home ownership and apartments and other things like that. I do think that there's some benefit in there. I think, though, that there is also a requirement to put protections within that legislation.
In terms of government announcements about FATF, there's a big gap between what they've said they're going to do, even up to as recently as the G20 on the international stage, and what's actually happened. We are way, way behind the government's own timeline that was set out of 2016. I know that we've had multiple ministers across multiple administrations under the Liberal National Party government leadership. And all of this impacts on how our dollar is actually valued and traded. The Australian dollar is actually one of the most traded in the world. What does failure to comply with FATF and bringing in Tranche 2 mean for the Australian economy?
Senator, I'm not an economist, but I'll make a broad comment about it, which is it's about trust in our economy. And about ongoing trust in our economy. There's no doubt, and there's a range of, and it's been a long time since I did my MBA, but there's a range of reasons why the Australian dollar performs the way it does certainly over the last 3 decades. But we can draw the conclusion that the trust in our economy, the trust in our brand, the trust in our dollar is critical to the future economic success of the nation. And that AML and CTF provisions are an important component of that trust.
Thank you very much, Dr. Coyne.
Thank you, Senator.
And so, Dr. Coyne, we have to conclude at this point because we've got another witness to come on at 12. So thank you very much for your appearance today. We do appreciate the time you've given us. So if there are any other questions, perhaps we can put to you
On notice.
You on notice. Would you mind doing that?
Thank you, Chair. No worries at all, Chair.
We need to suspend the hearing until 1:45. We'll be going into an in-camera session now at 12 o'clock. Thank you very much. International Australia, both in person and video conference. Thank you for taking the time to give evidence today. Information about parliamentary privilege, I trust, has been provided to you. And if you need further information, that's available through the Secretariat. The committee has received your submission and it's numbered submission number 17. Do you wish to make any corrections or any additions to your submission?
We don't wish to make any corrections. I understand that we have had an addition provided.
We've got that? Oh, there it is. Oh, sorry, it's under my thing. Okay, thank you. We'll take that as read. And for the Hansard record, would you both please state your full names and the capacities in which you appear today?
I'm Russell Wilson. I'm a non-executive director of Transparency International Australia. I understand my colleague is appearing by video conference, Serena Lillywhite.
Yes, can you hear me?
I can't hear.
So can't hear you? So with Hansard, are we able to fix that? Just see if we can hear you and can't hear us, so. Just well let it, so, Mr. Lillywhite, can you hear me? Thank you. Mr. Lillywhite, can you hear me? No. All right, we'll fix that. Would you like to make an opening statement, please, Mr. Wilson, while we're trying to fix our audio?
I'd have loved to, but
You haven't got it.
Ms Lillywhite was the one who was going to make the opening statement.
Well, we've got a technical breakdown here.
Yeah.
Mr Lillywhite's got the opening statement. Would you like to put up?
Ask her to disconnect from this and dial into the teleconference.
Right, but she can't hear me, so she won't. Can you hear me, Ms Lillywhite?
Yes, I can hear you now.
Oh, there we are, all sorted. Ms Lillywhite, would you like to give your full name and the capacity in which you appear today?
Thank you. My name is Serena Lillywhite and I'm the CEO of Transparency International Australia.
Thank you very much for joining us today. Would you like to make a brief opening statement before we go to questions?
Thank you. I would like to do that. Transparency International Australia thanks the committee for the opportunity to appear today. As we've made clear in our submission, Australia is highly exposed to money laundering and the flow of dirty money. FATF has confirmed Australia has become a destination of choice for illicit financial flows, particularly corruption-related proceeds, which too often do end up in the property market. And it's our view that our weak AML regime and flaws in our corporate registry and a lack of a public register of beneficial ownership is allowing that to happen. Indeed, AUSTRAC agrees. In their 2015 report, AUSTRAC stated that the laundering of illicit funds through real estate was an established money laundering method in Australia. By way of further evidence, we have are tabling today an annex to our submission, which provides 10 well-reported examples of money laundering through the real estate sector, and we've sent that through to you, and my colleague can also table. These examples show that money laundering into Australia's property market is coming from countries far and wide, from Sudan, China, Malaysia, PNG, Russia, among others. And it also shows that money laundering is linked to a variety of people: Sudanese generals, Malaysian bankers, PNG's political elite, and Chinese high rollers through casinos and property. Money laundering is not a faceless crime, and I request the committee give this consideration. It has devastating impacts both in Australia and overseas, and can reasonably be argued it is driving up property prices in Australia and locking many Australians out of owning their own home. And since making our submission in August, we've seen, of course, the release of the Pandora Papers, which laid bare the need for much greater scrutiny of offshore corporate structures and the flaws in Australia's own corporate registry system and anti-money laundering regime. Since then, we've also had the Victorian Royal Commission into the Crown Casino in Melbourne. That's concluded, and Commissioner Finkelstone's report found Crown's behaviour was, to quote, illegal, dishonest, unethical and exploitative. He found Crown links to criminal gangs and repeated breaches of money laundering laws. But despite that, he recommended the casino be allowed to keep its licence, albeit under a 2-year grace period. So I really think the headline question for this committee to consider is just how much evidence of money laundering in Australia will it take before the law is changed and enforcement is ramped up? Now, we understand that some lawyers, accountants and real estate agents are opposed to being covered by the AML Act on the grounds of a compliance burden, but we believe there are avenues open to prevent or at least ease this burden. And there are good working examples on our doorstep, such as New Zealand. We also think that the financial services sector, banks in particular, would welcome a fairer sharing of the responsibility to bear the brunt for scrutinising customers and their transactions for potential money laundering. So in short, we need a broader approach to tackling money laundering so the compliance burden isn't solely shouldered by financial institutions. And in closing, our submission makes clear what needs to be done to not only comply with FATF recommendations, but other strategies such as putting in place a national risk assessment of money laundering risks, the establishment of a public register of beneficial ownership, and strengthened capacity for AUSTRAC to both detect non-compliance among entities it currently regulates and broaden their mandate to other entities that are being used to commit and enable money laundering. It's important to remember that criminality finds opportunity, and the flaws and weaknesses in Australia's AML regime are providing that opportunity. Thank you very much.
Well, thank you. Senator Scarr, can you kick off for us, please?
Yes, Chair, quite happy to, and thank you for Transparency International for appearing before us today. I lived and worked in Papua New Guinea for a time, and I was also company secretary of a company with 2 operations in Laos. So I certainly found, in terms of discharging my obligations, a lot of the work that Transparency International did was extremely important. So I have a high regard for the organisation. I'd like to deal with some of the practical issues, and in particular, in terms of the class of what are referred to as politically exposed persons. And I think I've just had a chance to have a quick look at the submission which you presented today, supplementary submission, and I think some of the people listed in that submission fall within that category, potentially of politically exposed persons. So dealing with the situation, and I'm assuming, as I ask these questions, Ms. Lily White, that the vast majority of lawyers, accountants, real estate agents try and do the right thing the vast majority of times, right? So that's my starting premise. People might disagree with me, but that's my starting premise. So what do I do practically if I'm running a small conveyancing business, right? And maybe I'm doing other things as a lawyer. I've got a conveyancing clerk. I've got a receptionist. Someone approaches me and says they want me to act as a real estate, as a lawyer for them in a conveyance. Typically, that would be a service that might cost, it's been a while since I've been involved in it, but maybe $600 or something. What can I do practically to check and verify whether or not the person who approaches me is either A, a politically exposed person, or B, a relative or in some way connected with a politically exposed person? How do we make this practical, especially for the small businesses who are out there trying to do the right thing?
Yeah, thank you for that question. I mean, there's no doubt that for the small businesses, there is a learning curve that needs to take place. There needs to be training delivered for those small business operators that you mentioned, so that they are actually have the skills and capacity to understand what suspicious transactions look like, and to actually have a better understanding about what meaningful due diligence looks like. And there are a number of different ways that they can do that. If, for example, we had a public register of beneficial ownership, that would provide a basis from which they could have the skills to do that know your customer in a more effective way. Similarly, in reforming our AML system, there are opportunities to link it to, if you like, a broader ecosystem of reform that is needed. So it could be linked to our sanctions listing, for example, so that these small business operators know where to look for information. Are there potential clients listed on any sanctions list, for example? And of course, if our corporate register was more robust than what it currently is now, including, for example, the corporate register that ASIC has oversight of, currently it's almost impossible to have confidence that the data is held in that asset corporate register, because there is no verification of any of the data that is listed in that corporate register. And so for those small business entities, it is very difficult for them to know where to go to get accurate information. And that's why we would suggest that when we ideally we bring on tranche 2 and expand the scope to include other entities that are currently not regulated, there does need to be a period of grace, and also there is scope for professional industry associations to assist in the training that it will be necessary to have a better understanding about exactly what a politically exposed person is, and whether or not that information includes information as to members of their family, and also looking at the whole issue of wealth they may have accumulated that is not consistent with the salary they earn, for example. So I completely agree with you that there is work to be done, but this is not insurmountable.
Right. And so there is work to be done. And I hear what you say about beneficial ownership in terms of our corporate registers, etc. Right. So I appreciate that point. One of the points I think you make in the submission is, and if I go to page 7 of your submission, you say, and I quote, "There is also the risk given the reliance on commercial databases by reporting entities to identify high-risk customers, as these databases can often have missing or incorrect data. The FATF have said commercial databases are not necessarily comprehensive or reliable, as they generally draw solely from information that is publicly available, and thus the subscribing financial institutions or DNFBPs have no way of verifying the accuracy, comprehensiveness and or quality of the information contained in the database. We recommend that AUSTRAC should either develop a database for reporting entities funded from fees charged from reporting entities, or should at least audit the commercial databases." And I guess, end of quote, and I guess, Ms. Lillywhite, from my perspective, it's one thing to ask my hypothetical small conveyancing law firm, right, that's dealing with 100 conveyances, trying to keep the lights on, pay the rent, etc., to engage trawling through databases and working out if someone's related to someone who was a general in some particular sensitive environment. It's another thing, and I think far more reasonable thing, to expect a small business to access a government database to check and verify whether or not a red flag is raised with respect to an individual. Would you agree with that statement?
In principle, yes, I would, and I'll also suggest that my colleague Russell contribute to this response. But the point you make is a very good one, in that if we had a reliable, accurate database, which let's say is I note that Treasury currently has the Modernising Business Register program underway, which is a welcome step. They are attempting to consolidate what is currently 31 different corporate registers in Australia into one corporate register. And they are planning to introduce a director identification number, which is also very, very welcome development, because of course, many people can register companies and there can be inconsistencies in the way their names are spelt. That could be done intentionally or otherwise. And we welcome the introduction of a director identification number. But those initiatives that have been put in place do not go far enough. They don't address the issue of ultimate beneficial ownership disclosure, and they also, what is proposed does not address the issue of the use of trusts and nominee directors, all of which can be used as a veil of secrecy with intended opaqueness as a vehicle effectively to give a form of legitimacy if a company is registered in Australia, which can in some circumstances then be used for the purposes of money laundering. But I agree in principle, if there was one centralised, accurate, reliable database that has information that joins the dots around issues around politically exposed persons, sanctions list, linking to sanctions list held by DFAT and the World Bank and others, this would greatly assist small business operators to address that issue and be better placed to know their customer and have confidence in the system. But my colleague Russell is an expert on AUSTRAC and these things as well, so perhaps he has a follow-up response.
So, Mr. Wilson.
Thank you, Senators. Serena, I just had a couple of things. One is in regard to the first issue which you raised about what practically can the conveyancing lawyer do to identify a politically exposed person. It's as simple as doing an internet search, Senator. That should throw up whether there are any issues associated with that individual and whether that individual satisfies the definition of being a politically exposed person. It's then a further step consulting the sanctions list available on the Department of Foreign Affairs website as to whether there are any issues in respect of sanctions in regard to that particular person. Certainly there have been calls up for many years in regard to the last issue about a properly validated database of persons who are directors of companies, for example, rather than simply the collection of information which is unverified that currently appears on the ASIC website. The argument has largely been around the existence of such a database would then diminish the compliance costs of the other institutions which are regulated by AUSTRAC, and they could then just simply rely on that database for the purposes of performing their KYC checks, etc. Obviously, there are issues associated with resourcing the creation of that database and risks associated with being the sole source of truth, if I can put it that way.
So you're actually advocating my mythical conveyancing lawyer. He should just Google the name of a potential client. Obviously, they need to have, and I think the professional standards require this anyway, to be frank, in terms of understanding who they're getting instructions from and what those instructions are. So someone approaches me, I put the name into a search engine. Now, if there's some sort of indirect relationship with someone who potentially is doing something untoward in Myanmar, for example, or they've got some background in Russia, most internet searches that I conduct as your local conveyancing lawyer, they're just not going to pick it up, are they, really? I guess my concern is that there's a concrete, practical procedure that your small business owner can follow in terms of where to go and what to do, and that almost creates a safe harbour for them in the event that it turns out that the person they're dealing with is a cousin of a Sudanese general who, however, came into ungotten means. So that's the concern I have in terms of how we make it practical. And I note your reference to the internet search, but when I go to the submission from Transparency International, it actually talks about the risk of using commercial databases, that you might not get all of the information. And I'm sure, I think both points are right. The first thing I would do is an internet search. I think that's probably the obvious thing to do. But do you have any further thoughts in terms of how we make this practical for that small business in particular, so they're not overly exposed? Because we do have relationships with quite a few of our neighbours, and some of those neighbours, as Transparency International know, are high corruption risk countries. How do we make it practically as easy as possible for those organisations to deal with this change when it comes?
Well, the reference to my connection with AUSTRAC is the fact that I spent 10 years as AUSTRAC's first General Counsel, and therefore really helped AUSTRAC implement the current legislation and also put into place a lot of practices and procedures to do with administering the legislation. One of the things which AUSTRAC did and still continues to do is to issue a lot of practical guidance in terms of how to comply with the various requirements. And I'm reasonably confident there is already stuff available on its website in regard to what is a politically exposed person, for example, and how you might go about identifying a politically exposed person. I agree that it is a bit more problematic to have a list as such, which is regularly updated, which sets out not just the prime individual, let's say, but all of their relatives and so on as well. That's a difficult proposition. And that's where I think the problem lies in terms of having either a government or a commercial database in terms of the maintenance of it for that purpose. But the issue probably goes back to, well, what has the conveyancing lawyer done to try to satisfy themselves that this person is either or not a politically exposed person, or either or not on a sanctions list? And if they can show that what they did was reasonable in the circumstances, then that might well be sufficient, and guidance from AUSTRAC may assist with that.
Okay, all right. Okay, thank you, Chair. That was very useful. Thank you.
Thank you.
Senator O'Neill?
Pleased that Senator Scarr's got that practical assistance there, because there has been some static on the line for some time, Ms Lillywhite and Mr Wilson from the government about implementing this, despite claims in international fora and publicly here in Australia about implementation. They have failed to act, and there's been a litany of reasons advanced of why it's too difficult for us to do, despite evidence we received this morning that more than 195 countries have gone ahead and got their house in order with Tranche 2 while Australia's been twiddling its thumbs. So could I go to the statement that you've made that Australia is an attractive destination for foreign proceeds, particularly corruption-related proceeds. Are you able to detail the kind of criminals that I think you've provided with the additional supplementary evidence this afternoon? How are they washing their money? How does the practical reality work in the examples that you've provided this afternoon to the committee?
Serena,
I might start. Sorry, Russell, you go ahead.
Go ahead. Go ahead, Serena.
Thanks. Well, I guess there are a number of ways in which that can practically be done, and the way in which dirty money is flowing into Australia. And I think John Chevis this morning, indicated that there are many and varied ways that money is coming into Australia. And we provided, as you said, a number of examples today of just the extent of that and how that's being done. Certainly there are examples of it being done through casinos. There are numerous examples through the purchase and sale and indeed then renovation and upvaluing of property in the real estate sector. But also, of course, the purchase and sale of luxury goods, high-end luxury goods, cars, yachts, arts, jewellery. They are other common ways of effectively trade-based money laundering that exists. And then, of course, through a series of cash-based entities, whether it's a tattoo parlour or whether it's a nail parlour. There are many cash-based entities that exist that all provide for money laundering to get here. But perhaps the point I wanted to touch on relates to what effectively is we're seeing is really a proliferation of these professional service firms that are actually, their business model is actually to assist foreign individuals or entities to either secure a nominee director that in some cases they advertise as having an Australian sounding name. And these professional service firms are used to assist with the registration of companies in Australia that can then be used as a vehicle for money laundering. And similarly, there are also indeed, some law firms that promote their services as providing a backdoor to ASX listing. So I do think it's necessary that we look at this, as I said, this broader ecosystem of what are some of the other professional service firms and the way they're operating and how they're actually assisting those that want to operate in Australia under a veil of secrecy through either the use of nominee directors or trusts. And that's why we would also recommend that in addition to a public register of beneficial ownership disclosure, that include a trust disclosure and a requirement for nominee directors to actually disclose who they're acting on behalf of. But perhaps, Russell, I'll let you continue.
So just before we go to Mr Wilson, just so I'm clear on what you've just said to me, we're not just talking about the prevention of money laundering. You're now indicating that there are indeed some law firms and now companies that provide professional services that basically say to criminals, come on in, we'll facilitate your money laundering. And that is going on under the nose of AUSTRAC and other policing agencies.
That's right. There are.
That's pretty shocking, Miss Lillywhite. That's quite shocking evidence.
I think as we've made clear in our submission, that the use of legal persons and arrangements remain very attractive for criminals to be misused for money laundering. There are current loopholes in our system that do allow for non-licensed third-party providers to actually sell nominee director or shareholder services, and that then effectively hides the real identities and the ultimate beneficiaries and allows for these sort of opaque business structures to flourish. And we included in our submission an example of a Gold Coast based company that actually advertises they provide resident director services, allowing international companies to purchase nominee directors. And their website actually says, for a cheap price, you can ensure a cost-effective and seamless solution to overcome the major hurdle that the director residency rule can be for overseas businesses wishing to establish in Australia. So this is just one of many nominee service providers that are available in Australia that actually have a business model that is based on promoting confidentiality of services. And as we also mentioned in our submission, we included an example of a law firm that actually provides this backdoor ASX listing service.
So that reality is very important for us in terms of our understanding of the resistance from within the sector. I'm not saying that all law firms or all real estate agents nor all accountants hold such low standards and display such a lack of professionalism, but I guess criminals will flow like water to the lowest point, and if there's a weakness there, there's an opportunity for somebody to make a quick buck in the way that you've just described, that Australia is allowing them to do that. So they're doing that without fear of being caught up in the law by the sounds of things. Just before I move off that, you've talked a number of times now about the public register of beneficial ownership. You've also added to that there needs to be trust disclosure and nominee director disclosure. This corruption is not just related to overseas entities. Just last night on Four Corners, we had, I've got a transcript here of Jeffrey Watson, SE Counsel assisting the New South Wales Independent Commission Against Corruption, 2011 to 2015. Talking about land purchase on the mid-north coast of New South Wales at Hawke's Nest area. And it describes the OBEADS operation is simple. I'm quoting from this transcript. The OBEADS operation is simple, straightforward, and it's used over and over again. What it is that you have their involvement disguised or concealed by a $2 company with directors who are associates of the OBEADS, but with different surnames. Often it was then secured beneath that level by a trustee. They love a little trustee, a discretionary trust in which these people who are cooperative agree to hold benefits on trust for the OBEAD family. Is that the sort of practice that is possible for Australian businesses to conduct that is now basically a licence to launder money in Australia?
It's an example of the deficiencies within our current corporate register system that I've mentioned. It's an example of the fact that we don't have a register of trusts. It's an example that it is not necessary for nominee directors to disclose who they're acting on behalf of. And it's an example of the fact that we don't have a public register of beneficial ownership, which contributes to exactly the first set of questions that were put to us as to how do we actually go about assessing and determining, undertaking the necessary due diligence to determine whether a person or an individual is fit and proper to conduct business in Australia. So those examples that you've just made reference to are certainly replicated in the current gaps within our anti-money laundering regime, and noting that it's not just our AML CTF legislation, but it is this sort of ecosystem that I've mentioned. You know, we need to fix other things alongside just implementing tranche 2.
May I just add on that the issue is not, there's no issue about these structures currently being legally legitimate. They are. The issue, and there's not necessarily an issue that they cease to be legitimate structures that can be used. The issue is more of beneficial ownership and the use of them, particularly nominee directors, for example, to hide the actual beneficial owner who is actually purchasing the land, in your example. And that's the problem. And it's not uncommon to see this kind of layering that happens to seek to hide that ultimate beneficial owner as well, as in companies, trusts, etc.
It sounds like ACDC might have had it right. It sounds like you can do dirty deeds very cheaply in Australia at the moment. $2 company and off you go, and no one will know what's going on.
It's probably
I'll come back to this time.
Thank you very much. Senator McKim, are you available? We got you there?
Yeah, I am, Chair. Thank you.
Would you like to go ahead, please?
Thanks. I appreciate that. And good afternoon, folks, and thank you for your very comprehensive submission and your appearance today. Ms. Lillywhite, you've recently been quoted as calling Australia a go-to destination for dirty money, and you've made some similar comments to that today. So just to be clear, is it your view that Australia is a go-to destination for dirty money, at least in part because of a lack to legislate tranche 2 into the AML-CTF legislation, and also because of a lack of an ultimate beneficial ownership register in Australia?
Thank you, Senator. I think the short answer is yes. The fact that Australia is lagging behind international developments with regards to disclosure of beneficial ownership, the fact that Australia has not implemented tranche 2, all of this is creating an attractive destination. And it's not just Transparency International that has this view. The Financial Action Task Force has confirmed that Australia is an attractive destination for dirty money from particularly the Asia Pacific region. But of course, we've given examples of money coming from as far afield as Africa. So when you have gaps and weaknesses in an anti-money laundering regime, that does make it an attractive destination. And similarly, we also have other enabling factors, which I'm not suggesting are a problem, but we have a relatively stable and robust banking system. We have a relatively strong rule of law, and we have a very buoyant at the moment real estate sector. And then we also have sectors that are known as vehicles that are entities that are used for money laundering that are not currently covered.
Thank you. You, in your opening remarks, said that, I'll just paraphrase you and please tell me if I'm being unfair here, but you said it could be reasonably argued that some of the lack of rigour in our frameworks in Australia is driving property prices up and locking Australians out from owning their own home. And I note that Austrac's made some similar comments in a recent report that it's released a few months ago, one of its money laundering and terrorism financing risk assessments for major banks. Could you just explain how it is that you can come to that view and how that argument would run?
Well, I think the one point to start off with is I guess it's actually really difficult to find solid evidence to actually, hang your hat on, if you like, and confirm that money laundering in real estate has definitely driven up the price of property in Australia. But I do think there is enough anecdotal evidence to suggest that that's not an unreasonable position to hold. And I think also the fact that we know that we do have this gaping hole in our law, that it does mean that Australia is a more attractive destination than others. So I agree that it's and of course the whole kind of model of this is based on secrecy and opaqueness. So money launderers don't tend to sort of publicly get themselves out there. So it is an area that is difficult to find concrete evidence of, but I believe that the anecdotal evidence and the gaps in the law make it not an unreasonable position.
And in terms of, thank you, and in terms of I guess a mechanism for this to happen, I mean, you're basically, as I understand it, arguing that people who want to launder money through real estate would effectively be, competing at auction or competing in the marketplace with ordinary Australians who want to buy a home, and that increase in demand, if you like, would be one of the things that would be driving prices up.
I think it's a contributing factor, and I think it's also worth noting that there are professional service firms who will act on behalf of others to purchase property in Australia. I happen to be in the situation where I'm selling my own family home this weekend at auction, and was surprised to learn that there was an expression of interest in our family home from a professional service firm based in Sydney that has advised our real estate agent they are acting on behalf of a high net worth individual based overseas. You can imagine what I thought when I heard that.
And again,
you probably thought a lot more and knew a lot more about it than most people who are putting their property in the hands of a real estate agent. And that's part of the concern, isn't it, really, that a lot of people are doing this and they have no idea what's going on because they think the government's looking after it. Thanks, Senator McKim. Sorry, it's quite shocking, some of this evidence.
Yeah, well, it's not shocking to me that companies have seen a business opportunity in this space and are taking advantage of it. It's been going on for many years in this country, and it's one of the reasons that the Greens have been campaigning strongly for Tranche 2. I wanted to ask Ms. Leatherwhite if I could around an ultimate beneficial ownership register. Can you just explain in really broad terms for the committee, please, how introducing such a register would help to detect money laundering and terrorism financing, and how it would work? Like, who would be captured, who would host the register, how would people get access to the information on the register?
Well, there are lots of different models around the world, and I guess just as an opening comment, I'd say that this is the trend. The introduction of a beneficial ownership register is the global trend. FATF itself is reviewing its own recommendation with regards to beneficial ownership disclosure. And there's a recent consultation that they've conducted, and they're looking at potentially making stronger provisions around that. The EU, for example, has introduced its own directive which requires EU countries to put in place a beneficial ownership disclosure register. And it's one reason why, for example, the UK has one of the more sophisticated systems. Not perfect, but a lot better than what we've got. Encouragingly also, Canada recently announced that they would be putting in place a public register of beneficial ownership with a significant budget allocation to do so. So I guess there currently isn't a one-size-fits-all, and different countries have made different sort of progress, if you like. There are some countries that have beneficial ownership disclosure laws. There are others that have the beneficial ownership registers, such as the UK, EU countries, Slovakia, for example. And then there are countries such as Australia and Mongolia and Sierra Leone that have said, well, we might think about introducing one. They've made commitments at the UK Anti-Bribery Summit in 2016. They've made commitments and different governments, I might add, not just our current government, at the G20 anti-corruption, through the Anti-Corruption Working Group, and also through the International Anti-Corruption Convention Against Corruption, and even our own Open Government Partnership commitments were made to introduce a beneficial ownership disclosure register, and it just hasn't happened. And I perhaps go back to Russell on this point. I mean, if you've got the purpose of a beneficial ownership register is actually to try and give some visibility as to who's actually pulling the strings, who's in the driving seat, who is going to actually benefit from either a business transaction or through having a company registered in Australia. And it also provides greater visibility of whether or not, if you know who the ultimate beneficiary is that in fact a politically exposed person or the son and daughter of a high-ranking general in a particular country. As to how it will operate, I mean, I think undoubtedly there is work to be done on determining that, and as I said, there are many different models that can be used. I think the critical point, though, is that it needs to be a public register. And in Australia to date, there's been some talk about introducing a beneficial ownership register, but which is only available to certain government departments. So, for example, for the purpose, to the ATO, for the purposes of trying to identify financing or tax evasion. But that's not enough. We actually need to know who will ultimately benefit from these transactions. But perhaps Russell has something to add.
Very briefly, Mr. Wilson, we're out of time, right?
Nothing to add really in regard to that, but may I just, and the committee may well be aware of this, but corruption and dealing with the proceeds of corruption has actually been made a national security issue recently by the Biden administration. And I think that's a relevant point because it's not just financial integrity or sustainable development, but it's a far bigger and broader issue now as well.
Well, thank you very much.
Chair, can I just indicate I'll have some questions about AUSTRAC, because you've made a number of comments about AUSTRAC and your concern about their inability to notice systemic and large-scale breaches. So those questions I noticed to come.
No problems.
Thank you.
If you don't mind, if you take questions on notice, if that's all right? That's fine. You'll do the best you can to answer them. That'll be terrific. So thank you very much for your appearance today and giving us your time today.
Thank you.
Sorry? Thank you. Yes.
Thank you.
No worries, thank you. I'll just give him a chance to get off the stand. Thank you. Thank you. Thanks a lot. Thanks a lot. Oh, good. You want to find out who wants to go first? I welcome representatives of the Australian Banking Association via video conference. And I thank you for taking the time to give us evidence today. Information.
Good afternoon, sir.
Good afternoon there. I trust that parliamentary privilege information has been provided to you. Is that the case?
Yes,
Yeah, thank
correct.
you. The committee has received your submission and it's listed as number 22. Do you wish to make any corrections or have any further additions that you'd like to make?
I have a short opening statement, Senator.
Well, we'll get to that in a moment, so if you could. For a Hansard record, would you please state your full name and the capacity in which you appear today?
My name is Aidan O'Shaughnessy. I'm Executive Director of Policy at the Australian Banking Association.
Well, thank you very much. Would you like to proceed with a short or a brief opening statement?
Thank you, Senator. Good afternoon, Senators. The Australian Banking Association thanks the committee for this opportunity to appear and welcomes the committee's considered approach in examining how Australia's AML-CTF regulatory arrangements could be streamlined, modernised and strengthened. The ABA has 6 recommendations to enhance the effectiveness of the Anti-Money Laundering Counter-Terrorism Financing Act, which I am happy to talk to today. These include 1. Simplify both the AML-CTF Act and rules, which may remain largely unchanged from when they were first enacted in 2006, almost 15 years ago. In particular, the requirements relating to customer due diligence are overly complicated. Simplification and modernisation of Know Your Customer obligations is one area which would have the greatest regulatory impact. 2. Making both the rules and Act technology agnostic. Third recommendation is concurrently with the simplification and modernisation of the Act and rules, that Australia adopts the FATF recommendations 22, 23, 28, which relate to designated non-financial businesses and professions. The fourth recommendation is Australia adopting the FATF guidance on permitting simplified due diligence in certain situations. The ABA would also like to see Australia aligning the Australian domestic AML regime with the Wolfsburg anti-money laundering principles for correspondent banking. Finally, the ABA would welcome the Australia updating and modernising the Australian International Fund Transfer Instruction reporting obligations, also known as IFTIs. In addition to simplification and modification of the legislation, the provision of more advice and guidance by AUSTRAC for its regulated population would provide greater certainty on how reporting entities can best comply with AML obligations. An expansion of AUSTRAC guidance will also assist in reducing regulatory costs for new and existing reporting entities. The ABA consulted on the scope of this inquiry with its member banks before making a submission. Much of the committee's terms of reference focus on matters of AML-CTF policy and adherence to international standards, as well as matters that relate to non-financial businesses and professions and the detection and prevention of money laundering outside the banking sector. It is the role of Parliament to review policy, the performance of AUSTRAC and Australia's AML-CTF laws as they relate to other jurisdictions. It is not for individual banks to have a view on these matters, and that is why the Australian Banking Association made a submission and will give evidence on behalf of our members today. I'm happy to take questions.
Well, thank you very much, Mr O'Shaughnessy. And Senator McKim, would you like to kick off for the committee, please?
Yeah, thanks, Chair, and thanks, Mr O'Shaughnessy, for your appearance today. AUSTRAC have said to a Senate committee recently, and in fact, have said in a recent risk assessment of banks, that they expect banks to report any suspicions of professional facilitators or enabling parties to illicit activity. Are you aware of that expectation from AUSTRAC?
So, Senator, the AML-CTF Act, all of the provisions in the AML-CTF Act apply to Tranche 1, which is the financial institutions and casinos. Those obligations, my understanding would be naturally something that banks would report to AUSTRAC through a suspicious matter report. I know last year AUSTRAC received over 300,000 suspicious matter reports. So that is something that I would think would happen on a daily basis.
Sure. When I asked AUSTRAC about this in a recent Senate committee, they basically said they're relying on banks to tell them when lawyers, accountants and real estate agents might be facilitating money laundering, because lawyers, accountants and real estate agents are actually not covered under the Act, as you know, and as you submitted there in Tranche 2. How confident are you that banks actually can identify suspicious activity by lawyers, accountants and real estate agents? And would you agree that it would be preferable for the reporting requirements to be placed on those professions rather than using banks as the de facto reporters?
I think banks take their obligations under the AML-CTF Act incredibly seriously. So when they form a view or a suspicion about a particular transaction or customer, they will report it regardless of what profession that customer is. But in taking these obligations seriously, it has been the industry's view that implementing Tranche 2 is something that would be good for Australia because it would make us compliant with the FATF standards.
Yes, thank you. Would it reduce the regulatory burden on banks, given what AUSTRAC have said? Do you think it would reduce the regulatory burden on banks if banks didn't have to concern themselves with reporting on lawyers, accountants and real estate agents, the gatekeeper professions caught in Tranche 2, because if in fact those professions were required to report themselves rather than the banks having to report?
So, Senator, I think it goes probably to my first recommendation. The reporting, the customer due diligence requirements and obligations under the Act are 15 years old, and we see the legislation. In the time, that legislation hasn't changed much, but technology has come ahead in leaps and bounds. So I think if this committee was minded to recommend that both the Act and the rules were simplified, particularly customer due diligence rules, that actually would reduce the regulatory burden, not just for banks, but for also the 14,000 existing reporting entities, and for any new reporting entities that would come on board. I heard this morning from a number of consultants in the industry about the different technologies that are being used already in Australia, but also overseas, and that they have had a significant impact in reducing the costs of complying with the legislation.
All right, thank you. If Tranche 2 was included in the AML-CTF Act, if the gatekeepers were brought within the scope of that legislation, would that reduce the risks to Australian banks, and specifically would it reduce the risks of Australian banks inadvertently assisting money laundering and terrorism financing?
So Australian banks, as we stand today, take our obligations incredibly seriously. We're not only trying to meet the AUSTRAC standards, but the FATF standards, we also try to exceed those. I think as we look at the legislation as it stands today, strengthening the legislation, simplifying it, modernising it, all of that will go to meeting the objective of the AML-CTF regime.
All right, thanks, Chair, and thanks, Mr O'Shaughnessy.
Thank you very much. Senator O'Neill.
Thank you. Thanks for being here today, Mr O'Shaughnessy. Can I indicate that I am disappointed that we aren't actually hearing from some of your members? I had hoped that we would have heard from the Big Four because they actually have insights into how this is being managed that are not available for people who are from the DNFBP sector, and I'm kind of keen to understand how that's being implemented, what the costs have been, and the new technologies that are being employed as the banking sector comes to take it seriously. So I might just have a few that you might need to take on notice. So firstly, could you find out how much the banks have invested since 2013 per annum as a lump sum in counter-terrorism, meeting the requirements, the FATF requirements?
Yeah, happy to do so.
And if you could also do that for that period and per annum, so we can see if there's been an escalation. I expect there was quite a significant investment post the AUSTRAC cases regarding Westpac and National Australia Bank. Also, technology changes will have led to different opportunities. So I'm keen to understand, particularly by institution as well, per annum, Westpac, Commonwealth, ANZ, NAB, Macquarie and St George, just because they're the biggest ones, to get a sense of the scale, the cost and the degree of activity that's happening. And
Happy to do so.
that was my reason for wanting the banks to be here, because I do want to acknowledge that in the absence of government action to implement Tranche 2, the banks really are the thin blue line that is providing the heavy lifting in terms of any action on anti-money laundering and countering terrorism financing. So, if I could go to other witnesses' evidence that have discussed the effectiveness and the long-term sustainability of self-reporting processes, what's been the experience of the banking sector with the effectiveness of self-reporting and the regulatory burden that places on your business? And is that really your role, or what should AUSTRAC be doing in terms of detecting?
I think, Senator, probably there's 2 points here. One is my first recommendation, and then the second point is how AUSTRAC uses information. So on the first point on self-reporting, I think banks appreciate and understand the objectives of the legislation and want to meet those objectives. My first recommendation is that that legislation is 15 years old and needs to be simplified, and areas around allowing not just banks, but the 14,000 reporting entities to use new technologies to report information in a more efficient manner and to actually do customer due diligence. The second point is self-reporting to AUSTRAC, actually from the 14,000 reporting entities, builds the full picture for AUSTRAC and law enforcement. It is unlikely that one bank will have the whole picture, and feeding multiple entities feeding information into AUSTRAC and other law enforcement entities allows those enforcement agencies to build the whole picture.
How much, in your view, would the whole process in Australia be improved if Tranche 2 had already been implemented? What would the impact on banks be with the implementation of Tranche 2?
It's an interesting question, Senator, because I'm not quite sure that much would change with banks. There's a culture of positive compliance with international standards in the banking sector because we are reliant on overseas markets. So when it comes to capital and liquidity, we try and adhere or exceed the BAL requirements on capital and liquidity. When it comes to international accounting standards, we adopt the international standards into the Australian rules. And when it comes to AML/CTF obligations, we try and meet and exceed the FATF standards, because when we go overseas, we want to be able to say we seek the funds that Australians need to buy their home or purchase their car. And the overseas investors always have a tick list of all of these different obligations that are imposed on banks, and we try and demonstrate how we comply with those. Where we are, and I recognise that FATF have rated us non-compliant in certain areas. Whereas that is the case, our members provide further information to overseas investors so that those overseas investors are satisfied that Australia's banking system is secure, robust, well capitalised, and takes its obligations seriously.
So there's a regulatory compliance burden placed on Australian entities, the 14,000 that are already captured, because of doubt about our transparency and our compliance with FATF. Is that correct?
I think having the FATF rating on certain recommendations change from non-compliant to compliant would certainly be more efficient for banks as they seek funds overseas. But right now, we are meeting those obligations through our own efforts to work with our investors in overseas markets to show how we comply with both the letter of the law and the objectives of the money laundering legislation.
So I don't want to verbal you, but I want to be clear here that because Australia has so many elements that are non-compliant, it requires workarounds by the banks to be able to access international capital and comply.
I wouldn't say workaround, Senator. I think it would be for the Australian banks demonstrating to overseas markets the steps that banks here take to ensure that we meet both the spirit and the objectives of the legislation. So I would call it more paperwork than anything else, as in
Yeah, so
evidence.
it's inefficient and it definitely doesn't meet your test of simplification that you said was the priority that should occur.
Definitely, the preference would be we will continue to meet our obligations, but it might become a little bit more efficient if we were compliant with, if FATF gave us a compliant rating.
Excellent. And if time allows, I'll get to the 2016 plan of work from the government. I think 49 of the 60, let me just get this number right, 49 of the 64 recommendations have been advanced. 49 of 84 recommendations are ongoing or outstanding. That leads to a concern about Australia's capacity to stay out of the grey listing zone with FATF. What does grey listing mean? What impact would that have on the efficiency of business for Australia if we end up in the grey list?
So I was listening to some of the witnesses this morning how described that a grey listing might require increased monitoring of Australia by overseas jurisdictions. I think when it comes to the banking sector, as I said, we take our AML CTF obligations quite seriously, and we have year on year, as we seek the funds to provide credit to Australians, we demonstrate to overseas investors how we comply with the banking capital and liquidity requirements, accounting requirements, financial stability board reporting requirements, and AML CTF obligations. So we're already doing the work there, Senator.
Well, you are doing the work, but there's a tranche that has not yet been advanced that puts the whole ecosystem at risk if the government doesn't push on with tranche 2. Could I just ask you this? Given that we've acknowledged there's been a significant investment by banks made in recent years into AML and CTF compliance and the reliance of AUSTRAC on banking SMRs and other intelligence, does the ABA or your membership believe that criminals will instead target non-regulated sectors and move their money beyond the banking sector? And if so, do you have any evidence of this taking place?
I wouldn't have any evidence of that taking place, Senator, sorry.
Do you have a view about the likelihood of money starting to move away from your more regulated, more oversighted flows of money into a less observed and less reported sectors of the economy?
Listening to the law enforcement agencies this morning, that would be a logical assumption.
The ABA's submission states that the sector supports the implementation of Tranche 2 as a priority, as have most of the witnesses today. What benefits do you see for Australia as a destination for clean international capital if these reforms are passed? And could you also reflect on that in terms of Australia's positioning in Asia, in the Asia-Pacific region as a significant financial service hub?
So Australia's position in Asia, I think, in the sphere of AML CTF, I think there's credit to AUSTRAC. Their financial intelligence unit is recognised as being possibly one of the best in the world, and we've seen over the last few years the amount of work, or I've observed over the last few years, the amount of work they have done with our neighbours in Asia to not only lift standards here in Australia, but to lift standards with our neighbours as well. It's right now, when Australian banks go overseas to overseas funders to seek the funding we need to serve Australians, we are seen as a strong and solid banking system, strong, stable banking system. We have gone through the GFC and we've just gone through a global pandemic. And both of those have demonstrated, not just here at home, but overseas, that we have a banking system that is solid and stable. And throughout that time, part of that process of demonstrating we're solid and stable, it was banks doing the individual work with their overseas investors to demonstrate how they comply with capital, liquidity, accounting, and AML obligations.
Thank you very much. Your submission supports the complete implementation of the recommendations from that 2016 statutory review of the Anti-Money Laundering and Counter-Terrorism Financing Act of 2006. You indicated items 22, 23 and 28, I think, in your opening statement were critical recommendations that remain outstanding from the review. Do you want to speak to that and give us a sense of the impact of a failure to regulate?
So recommendation 22 and 23 relate to designated non-financial business and professions. 22 obviously is the customer due diligence obligation, and 23 is the reporting of a suspicious matter to AUSTRAC. 28 goes more to the supervision model applied. I actually think right now it is almost the perfect time. So we have seen, we have always been conscious in Australia about putting red tape and the regulatory cost on small business. Now, there are 14,000 reporting entities already reporting to AUSTRAC, so they suffer that the cost, the regulatory burden there, hence the recommendation we made to simplify the customer due diligence rules, which will actually remove much of the red tape because you can use technology to solve the problem for these small businesses. And if I look at how the other jurisdictions who I think Australia is best to compare themselves, like the United Kingdom, the European Union, our trading partners in Singapore, and how they've implemented Tranche 2, I think that we can learn from all of those jurisdictions, New Zealand included, on how they have used technology to actually make it a much more simpler implementation and actually not a very expensive one. So suddenly the benefits of implementing it now using technology far outweigh the costs. And I listened to some of the experts this morning estimating the cost in New Zealand. So it was always a concern that it would be a regulatory impost and a significant one on these professions. But I think given the advancement of technologies, not just used by banks today, but across the economy, the cost is significantly lower and the benefit remains.
Given the importance of detection and evidence we've had today about how important it is to have CEOs and the board members cognizant of responsibilities, even being personally responsible for making sure that AML and CTF requirements are adhered to. I just want to point to an article by Charlotte Grieve in the Sydney Morning Herald on the 27th of August this year, which talked about incentives to cut corners when the employment of contractors becomes a financial risk. And I recall evidence that we received during the auditor's inquiry that sometimes banks were actually just bringing in staff from an auditing company, the auditing company making claims that they had high-level counter-terrorism finance analysis skills that were found to be somewhat wanting. Is it important to have staff within the bank carefully monitored, perhaps even with KPIs, to make sure that they are doing their work properly rather than leaving it to chance and external contractors coming in?
So, Senator, I'm not aware of that article, so I'm afraid I can't comment without reading it.
So we might send that one to you on notice, if we could, Mr O'Shaughnessy, just to get your view.
No problem.
With regard to AUSTRAC, just a couple of quick questions if I can. One of the things I noticed when I looked at the enforceable undertakings, there weren't very many of them on the AUSTRAC website. There was one about a pub in Bradbury that was quite old. Bradbury, a suburb of outer western Sydney, New South Wales, and it was the George Thomas Hotels. It went to the level of training and vetting to make sure that people understand their responsibilities. So I want to go to what level of vetting do banks undertake to ensure their own staff are not involved in using the bank systems for money laundering? And how common is it that banks have to report their own staff to law enforcement for breaches?
I Senator, I can assure you the banks take their anti-money laundering, counter-terrorism financing obligations very seriously. We have a tough regulator who's willing to take action. We've seen that in recent years. So there's never been greater focus and attention on this. A lot of banks are risk managers, whether it is money laundering risk or operational risk or credit risk. They are risk managers. So every process, policy and procedure in a bank is about making sure that the right steps are followed. And it's not just trusting your staff, but it's also verifying that trust. So you trust your staff to take steps in accordance with the policy, but there's verifying as well through the internal processes like internal audit and elsewhere. If there was ever a matter where there was an issue was found, you would expect banks would take the appropriate action, depending either reporting to law enforcement or AUSTRAC or both.
So we're not seeing sort of in-house management of issues where staff have done the wrong thing. Would they always be reported, or would it be treated quietly as an in-house matter? And what happens if there's whistleblowing? Because we are seeing a concern about the culture of whistleblowing being dissuaded.
I don't know if I would agree with that view, Senator. In recent years, the Australian Banking Association, as part of our Better Banking programme, introduced whistleblowing protection within the industry, and that has been bedded down over recent times. So I think that's actually working well, and there's actually a culture of speaking up in the industry. We have just come out of a Royal Commission, and I think we are fully appreciate what was revealed during that Royal Commission, and we have learned the lesson that if you see something, to speak up.
Mr O'Shaughnessy, can I say I appreciate the fact that the policies are in place, but I still hear from whistleblowers who are concerned about being shut down right across the financial services sector, not just in banking.
Mm-hmm.
So I don't know that all is well with the world there just yet. Could I go to the level of collaboration between the major banks' cybersecurity and anti-money laundering teams? What's the level of that, and is the ABA concerned about Australian bank accounts being sold on the dark web?
So we've seen this year, Senator, the Home Affairs have introduced quite a large piece of legislation called critical infrastructure legislation, which looks at the topic of cybersecurity. Included in that, they're looking at different sectors across the economy, and looking at those critical sectors which needed to be addressed first. It wasn't banks, because in the engagement with the banking regulators and banks themselves, it is recognised that banks take cybersecurity incredibly serious. It is one of the topics that dominates, including AML, that dominates the conversation of board members in all of our banks, because it is a clear and present risk. In interviews with CEOs, when they're talking about radio, they will talk about a huge number of phishing attacks on banks' types of software and hardware and services. So it is front and center for all banks. They take it incredibly serious, and it's good that Home Affairs are actually introducing this legislation. We need to get it right, but it is critical that the banking sector and other sectors cooperate with the Cybersecurity Centre, Report Cyber and others, to make sure that these types of risks are managed. I'll go back to an earlier point that banks are risk managers. So cyber risk, AML risk, operations and credit risk is the culture within banks. So they don't shy away from these dangers. They actually say, well, how do we mitigate this risk or prevent this risk from happening?
The bank accounts that are being sold on the dark web, what's the scale of that? Is that a new place that money laundering is occurring?
I understand the question, Senator, but I'm actually not quite sure what you're referring to. Are you referring to an article or a paper or? No,
nothing in particular, but I understand that there are the reports of Australian bank accounts being sold on the dark web.
I'm not aware of that report. I'm happy to take that on notice and have a look at that for you.
Thank you. If you could, and find out how that is detected and what's been going on with that. And is there a threshold for reporting customer accounts on the dark web to the Privacy Commission or the Australian Information Commissioner? So a little detail there. Could I also go to the issue of money laundering through cryptocurrencies and some changing interactions between different parts of your membership with engaging with cryptocurrency? I know that some cryptocurrencies have been just cut off and shut down. The CBA look like they've taken some significant steps lately to engage with that, allegedly to engage with the youth market. What's the risk of cryptocurrency with regard to money laundering?
So, Senator, it's a fantastic piece of technology and a concept that I think everybody across the finance sector is looking at cryptocurrencies and blockchain and the benefits they can offer. The simplest way, the simplest issue with cryptocurrencies is its anonymity. So a basic tenet or a core obligation of the AML/CTF Act is know where the money is coming from, know where the money is going to. And because certain types of our virtual assets have a level of anonymity or can be traded on exchanges with a level of anonymity, that does not allow traditional players in the finance sector to be able to, with confidence, to report that they know where the money has come from and they know where the money is going to. So that's the problem that I think we're all, the entire industry, and not just Australia, but around the world, is grappling with. I do note that the FATF in the last 2 months have finalised or updated their guidance on virtual asset service providers. And that is something I'm hoping that Australia will look at and adopt in the coming years. I think
so.
It's
go on.
Sorry. I think there is a desire from certain operators within the digital assets and digital currency space to be brought into the regulatory sphere. And I think that will help us grow that environment once we can kind of together figure out how best to ensure Australia remains protected, but also embrace what these technologies can offer us.
So that's a question on notice then probably for the Commonwealth Bank and any other banks that are members of your association who are adapting their business to engage with cryptocurrencies. How are they overcoming that threshold issue of the identity of that money and its movement through cryptocurrencies?
Senator, I probably can answer that right now. The CBA initiative is in pilot stage, and it is in close cooperation with working with regulators to figure out how the trading in that pilot is our 10 digital assets and traded within that kind of safe environment. There's another bank called Revolut, which is applying for a banking license in Australia, and they call it a garden wall, that their customers are within the garden as well. So there is not actually an answer to these problems yet, but I think it's just sitting down in real life scenarios with real life customers, figuring out, well, if we were to recommend something in Australia, what could it look like?
Is that actually a regulatory sandbox approach? Because I asked questions about that earlier today. Is that sort of a by default regulatory sandbox approach that's being undertaken by the private sector in the absence of government action?
I think you could call it something similar to that. Yeah, it is a pilot that is looking at saying it is in a controlled environment, and how best do we ensure that it's a good service for customers, but also meet our obligations, and as problems arise, engage with those outside the sandbox, like the regulators, to say, here's a scenario, how should we treat this?
Okay, that's very helpful. Thank you very much.
Thank you very much, Senator O'Neill. Senator Scarr, are you right to go?
Yes, I am, Chair. I'm just starting my video. Okay, thank you, Mr. O'Shaughnessy. Thank you for attending today. There are 3 areas I'd like to cover with you. The first relates to debanking and de-risking. So in conjunction with the introduction of AML procedures, there has become a phenomenon where customers in particular sectors, which the banking industry might see as more high risk, have suffered from the phenomenon of debanking. Is the Australian Banking Association looking at whether or not it's getting the balance right in terms of meeting its obligations with respect to AML requirements, but also making sure that legitimate businesses, legitimate customers aren't being prejudiced by overzealous debanking processes?
So, Senator, I note the release from AUSTRAC last week, which called debanking a complex and global problem. The issue pretty much rests with anybody who reports to AUSTRAC, or the banks that report to AUSTRAC, must be able to tell AUSTRAC and other law enforcement where the money has come from and where the money is going to. When you have a bank which has a direct relationship with a customer, that is relatively easy. You can identify who the customer is, you can identify the source of wealth, and you can identify where it's going. It becomes more complex for certain parts of the economy where a bank's customer has customers, and that they might be, I'll give an example, we've just discussed trading virtual currencies. So it becomes very difficult for a bank or another reporting entity to with confidence, say, with that customer who's trading with other customers that we can't see, we do not know where the money has come from or where the money is going to. So it becomes very hard with these particular sectors to balance adhering to the AML-CTF legislation. And this is probably, I'll go back to my earlier point, the legislation is 15 years old. We would long to see it simplified, modernized, to be actually see if we can actually address some of these issues in debanking. Not every sector. Some sectors are probably too high risk for banks because they'll have a certain risk appetite. For some of our banks, they'll have obligations imposed on them by their overseas partners, correspondent bankings. And they may not, for some sectors, satisfying the legislative requirements like sanctions or AML-CTF might be impossible given the anonymity of certain products and services used in those sectors.
One of the examples we heard at a Senate Select Committee looking at the FinTech, RegTech industry was that a lady entrepreneur had set up a Bitcoin business. A bank had made a decision to debank her business. But after that decision was made, she had tremendous difficulty in her personal capacity. So she had been a director and owner of the Bitcoin business. She then had issues in her personal capacity opening a bank account with anyone. And obviously that raised issues in terms of her just getting things as simple as utilities connected or renting premises. Are you aware of those sorts of issues that are in the system, and how do we address those? Because from my perspective, hearing the testimony from that person, she was absolutely beside herself. No one would tell her why they wouldn't open a bank account with her, but we thought, or she thought, that it was because she'd previously had her own Bitcoin business that had been debanked for some of the reasons probably you've just outlined, but it was then impacting her as an individual. And there was no evidence, certainly before the committee, she'd been involved in anything untoward, but she was suffering from this phenomenon of debanking.
Yeah. And Senator, there's a number of things that I get how some customers might be frustrated if a bank who they've been with says, we can no longer offer you services. There's a section of the AML-CTF Act, section 123, which is the tipping off provision. So once a bank or any reporting entity forms a suspicion and reports that suspicion to AUSTRAC, they must not tip off the company or the individual on which that suspicion has been formed. And the purpose of that is that the report goes to AUSTRAC and AUSTRAC shares it with law enforcement. And law enforcement will then make the choice and contact the bank and say, let the activity continue because we want to see where the money goes. So there's this obligation, if the bank forms a suspicion and reports it to AUSTRAC, they cannot tell the individual about this suspicion being formed. That is actually if they do, they breach the act, and I think it is actually a criminal offence if an individual in the bank does it. So the consequences of a bank doing it is severe. But I do fully appreciate at the other end, the customer is told nothing and has no visibility of why they have been, their account has been closed. But that's one of the areas. There are other examples of why a bank account would be closed.
Okay. I've got two more areas I wanted to touch upon. In your letter or submission from the ABA, 27 August 2021, there's a paragraph, and I'll quote it for the benefit of everyone. Should the above reforms progress, the current AUSTRAC industry contribution model will also need updating, such that it is representative of the AUSTRAC regulated population, end quote. You didn't cover that in terms of your opening statement, Mr. O'Shaughnessy. I'm just wondering, what would you propose as part of that? What's the ABA actually proposing in practice in terms of who bears what costs? Because from my perspective, obviously the banks are at a scale. You've got economies of scale, you've got the expertise. At the other end of the spectrum, which I continue to refer to in the course of these proceedings, is a single law practitioner who's running a little conveyancing business, and he's trying to grapple with the regulatory burden, do everything else they have to do. Where should the cost of this fall in a fair and equitable way?
So thank you, Senator. Good question. Banks do have economies of scale, but I'd probably argue when it comes to the AML/CTF legislation, it needs to be modernised so that we can all reporting entities can use new technologies to adhere to their obligations. So we may have economies of scale, but the cost of administering and adhering to the obligations under the Act are significant. If in that review of the AML/CTF Act, the role and the regulated population of AUSTRAC gets expanded, the ask is simply that the government adheres to their cost recovery guidelines, that those that generate the cost of regulation bear the cost of regulation. So right now, I keep repeating this figure, AUSTRAC have about over 14,000 reporting entities reporting to AUSTRAC. Only 500 of those entities actually pay the AUSTRAC levy. So 500 entities out of 14,000 fund AUSTRAC in its entirety. And that is an issue. That if AUSTRAC changes its role or it expands its role, that it has to be a much more equitable model on how it's funded. I do note that in the last decade, AUSTRAC, due to the work of banks and other reporting entities, has allowed the tax office to issue notices for an extra $2.9 billion in tax, which has been, I think, has been recovered. And that would be one suggestion, that rather than having industry fund AUSTRAC, that the recoveries that the industry and reporting entities facilitate in partnership with AUSTRAC can be used to fund AUSTRAC and then fight further financial crime.
Okay, just my last question then, and this has been a consistent theme, I think, through your evidence, in terms of the need to modernise and simplify the procedures under our existing AML legislation. Is it your evidence that, to the extent we look at rolling out the legislation to Tranche 2, we should actually undertake that modernisation and simplification process in conjunction with rolling it out to Tranche 2 to make sure that the process is as efficient as possible as we extend it across to thousands and thousands of additional businesses?
Absolutely, Senator. And not just that, but that will also benefit the existing 14,000 reporting entities. Modernising the legislation will benefit existing and new reporting entities. So absolutely, yes.
Okay, thank you very much.
Well, thank you very much, Mr. O'Shaughnessy, and that'll end this particular session. I might suggest we could cut the break a little short, perhaps give us another 5 minutes or so. So I'll suspend the committee for 10 minutes, so for an afternoon tea break. Is that okay? 10 minutes? No worries. Okay. Resume in 10 minutes. Thank you. Australia and New Zealand via video conference, Institute of Public Accounts, the Financial Planning Association via video conference, the CPA via video conference, and I thank you all for giving us your time today. I trust that parliamentary privilege information has been provided to you, and there's additional material available if you require it. We have here submissions number 5, number 9, number 11 and number 37. If there are any additions or corrections to those submissions, does anyone would like to make any changes? All good? Okay. For the Hansard record, could I ask each of you please to state your name and the capacity in which you appear here today? Start.
If I may take this one.
Yeah, that'd be really helpful. One, you can breathe, and two, we can hear you.
Thank you, Chair. My name is Vicky Stiliano, and I'm from the Institute of Public Accountants.
Right. Who'd like to go next? Ms. McWilliams? Can you hear me?
Yeah, my name's Cam McWilliams, and I'm the Business Reform Leader at Chartered Accountants Australia and New Zealand.
Who's next?
My name's Benjamin Martian. I'm the Head of Policy at the Financial Planning Association of Australia.
And my name is Ketty Waller. I'm Head of Public Practice and SME at CPA Australia.
Thank you. Would each or any of you like to make an opening statement?
Thank you, Chair. I will start and then pass on to my colleagues. Thank you for the invitation to present to the committee today. Firstly, I would like to acknowledge the traditional custodians of the lands of Australia and their continued connection with the land, waterways and communities, and pay our respects to their elders, past, present and emerging. Chartered Accountants Australia and New Zealand, CPA Australia, Financial Planning Association of Australia, Institute of Public Accountants together represent over 350,000 finance professionals in Australia, New Zealand and around the world. Through our combined membership, we represent over 80% of financial planners who have actively been involved in the regime for over 10 years. We welcome moves to strengthen regulations that fight money laundering and terrorism financing. Money laundering and terrorism financing are illegal practices that severely damage our financial system. We support the global initiatives to combat this activity and recognise the importance of Australia meeting its obligations as a member of the Financial Action Task Force. As professional associations for accountants and financial planners, we are committed to acting in the public interest and contributing to a robust system that prevents criminals from using Australia for illegal activities. Our members work across a wide range of sectors, including in practice, from large firms to sole practitioners, large financial services providers to self-licensed advice businesses. In business, from major multinationals to SMEs, the public sector, not-for-profits and academia. We hold our members to high professional and ethical standards, including the requirement to undertake a degree of customer due diligence, meet record-keeping requirements, and to undertake screening for and to be aware of suspicious behaviour by new and existing clients. Lastly, I refer to the IPA's office in the UK, which is an authorised supervisor for AML purposes and supervises approximately 2,000 member firms. We know from their experience that a proportionate, risk-based approach is essential, and that an overly complex system, such as in the UK, has resulted in significant compliance costs in order to meet the AML CTF obligations. I now hand over to Ketty Waller from CPA Australia.
Thank you.
Thank you, Vicky. In our submissions, we have aimed to assist with shaping the future design and implementation of the expansion of the regime to include the accounting profession, balancing regulation with risk, and strengthening our members' contribution to detecting and reporting potential money laundering and terrorism financing. We note the importance of undertaking an analysis of the AML CTF risks compared to the cost of compliance for businesses that would be captured, including, if applicable, any industry contribution levy. It is important to be cognizant that money laundering and terrorism financing risk is proportionate to the size of a business, the number, nature and location of clients, and the value of transactions, so policy responses should be pragmatic. For example, we are supportive of imposing the obligation to undertake customer due diligence, or CDD obligations, on all providers of accounting services. Such an obligation should not only reduce the risk of money laundering and terrorism financing, but it is also good practice for firms to verify their customers' identity. However, the ATO and the Tax Practitioners Board recently released client verification guidelines that align with the AML CTF CDD requirements, meaning that tax practitioners are now performing these checks. Furthermore, professional accountants have additional obligations under their Code of Ethics that requires that they must respond when they become aware of non-compliance or suspected non-compliance with laws and regulations. This includes money laundering, terrorism financing, and proceeds of crime. It is therefore evident that some of the AML CTF requirements and obligations significantly overlap with or emulate existing professional requirements imposed on the members of the accounting profession by their respective professional bodies. Importantly, these obligations only apply to qualified accountants, as opposed to those that may call themselves an accountant, but who are not members of a professional accounting body. I would now like to hand to Karen McWilliams, Chartered Accountants Australia and New Zealand.
Thank you, Kelly. In developing our responses to the committee, we engaged with our respective memberships within Australia and overseas, particularly in New Zealand, where our members are already subject to requirements under New Zealand's AML CFT legislation. From their experience, there are some critical factors that we consider will assist with achieving the greatest benefit from Tranche 2. Firstly, that an assessment be undertaken on which existing mechanisms have led to the successful identification of money laundering and terrorism financing activity. Such an assessment should then be used as a basis to determine any future requirements and obligations for accountants. Secondly, as Vicky and Keddy have highlighted, our members are already subject to a wide range of existing professional and ethical standards. The inclusion of accountants should take into consideration existing regulatory obligations and industry oversight that could be effectively leveraged. The duplication of existing compliance obligations on accountants would exacerbate any compliance burden and associated cost, particularly for our small practice members. And an unintended consequence could be higher costs to small businesses and consumers for accounting services, as small practices seek to pass on their increased cost. Further, small practices may cease to offer designated services if compliance obligations are excessive, which may in turn inadvertently displace the risk of money laundering and terrorism financing to service providers that are not members of a professional body or outside the regime. We recommend a cost-benefit analysis of the regulatory options for accountants is undertaken, including, if applicable, any industry contribution levy. Thirdly, there should be extensive consultation with a broad range of stakeholders throughout the process, including raising awareness with consumers. This will contribute towards a more effective and efficient regime and establish a collaborative approach to increasing the resilience of Australia's financial system to criminal threats. Critically, the design must recognise accountants are inherently different from financial institutions and will require specific amendments to the regime rather than simply being captured under the current regime. I'd now like to hand over to Ben, representing the Financial Planning Association.
Thank you, Karen. From the perspective of Financial Planning Association members, financial planners have been subject to Part B programs for over 10 years and have been an outsourced professional for the Part A programs of financial service product issuers. Our members have benefited greatly from the willingness of product issuers to develop and adopt an industry standard ID verification form through collaboration between the Financial Services Council and the FPA. Unfortunately, not all issuers have adopted the industry standards, superannuation funds in particular. And despite the government adding financial planners to the statutory declarations approved witness list, not all issuers will accept financial planners ID verifying their clients, despite the professional relationship they have with their clients. An emerging issue we would like to see supported by the government and AUSTRAC is a technology-first ID verification process used by Part A entities to support the Know Your Client obligations. Despite significant advances in ID verification services over the past 10 years, virtually no product providers will accept a technology-enabled ID verification service and would prefer to still receive a certified photocopy and a wet signature on a form. While this is generally frustrating, the current pandemic has shown the issues with this approach when trying to support Australian consumers manage their financial affairs. In conclusion, while Australia has a comprehensive and tough money laundering and proceeds of crime laws in place, further efforts to prevent financial crime are a good thing. As professional bodies, we stand ready to assist with this challenge, and we welcome the chance to discuss our submissions and these issues with you here today. Thank you.
So, Senator Scarr, are you right to head off for the committee?
Yes, I am, Chair. Thank you all for attending today. And I note, I think you're the first witnesses we've had during the course of the day who are representing people who form Tranche 2 who will actually be impacted by the rolling out of the Tranche 2 reform. So I think your evidence is going to be important, as has been all the evidence we've heard during the course of today. The first question I've got is, as part of rolling out the reform to Tranche...
Paul, we can't hear you. We've lost you. You can't see us either.
As part of that process, prior to rolling it out to
Senator Scarr, we've lost your audio for a while. Could you just repeat your question?
Yeah, sure. Well, I paid you all a number of compliments first, so just take that as noted.
We'll take the compliments as read. Yeah.
As read. The main point I was asking is, does there need to be a simplification, a modernisation of the Know Your Customer due diligence requirements under the legislation prior to rolling it out to Tranche 2? That's the first question. The second question is, as part of that modernisation process, does consideration need to be given to the specific circumstances of each of the body of professionals that you represent to make it fit for purpose for each profession, if you like? If I could go to the Chartered Accountants first.
Thank you, Senator. I think I'll probably best to respond to, I guess, the second part of your question around really, does it require a tailored response? And I think, as I indicated, sort of accountants will need to have a sort of tailored, I guess, response to this. They're not the same as financial institutions, and their interaction with their clients are different. They are also already subject to a wide range of obligations under existing both ethical and professional standards, but also, as I think Keddy indicated, already under the ATO as tax practitioners. So I think all of those things need to be taken into account. But I suspect Ben is probably best placed to specifically comment on, I guess, the Know Your Client CDD and how that actually should be perhaps modernised before rolling out.
Yep.
Thanks, Karen. As I noted in the opening, financial planners have been subject to Tranche 2 obligations, Part B obligations under the AML-CTF Act, and have been doing the Know Your Client requirement on behalf of product issuers for over 10 years. I'll probably take a slightly contradictory view here to my colleagues, in that financial planners are under so much regulatory change at the moment, and the Know Your Client obligations and the providing ID verification and the forms we've developed with the Financial Services Council are fairly well embedded. They have been for 10 years, and any changes to the process or the obligations around that are just another change and another cost that financial planners are going to have to bear. So from that perspective, the FPA is quite comfortable with the item 54 reporting obligations that financial planning licensees have, and we wouldn't really want to see a change in the Know Your Client obligations at this point. But I guess the main point would be, when you have a professional relationship with a client, it's quite easy to know who your client is from a financial planning perspective, because you're generally dealing with an individual. It's much more complicated, I think, in accounting, because you have a lot of different business structures and trust structures and organizational structures, and knowing your client and providing the right kinds of documentation in that framework is a lot more challenging than what it is for financial planners.
Okay. The Institute of Public Accountants?
Yes, thank you, Senator. I might just add to what my colleagues have said that I think it's important to also look at the client and document verification requirements that are flowing through the ATO and the Tax Practitioners Board at the moment. We're looking at having a consistent standard and having a look at developing minimum standards. And I think in time we'll see how the implementation goes, what needs to be changed, and to see how it can be tweaked. I might also add that there's also a lot of other regulatory reforms that are flowing through. There's the director ID requirements, there's the modernising business registers changes that are taking place. So I think it's also important and useful to have a look at the cumulative effects of these and other regulatory reforms, and to see how they're implemented and how practically they're going to sort of work in the future.
So is it fair to say we shouldn't be looking just at what's under the AML legislation, but we also need to consider the professional standards, the ethical requirements of those who are members of your relevant organisations, also what's happening in the taxation space in terms of director identification? We need to consider all of that globally, and then once we've done that, come up with, as user-friendly, the most efficient and effective process which is suitable for each profession. Is that a fair comment?
Yes, I would agree with that, Senator. I think it's critical to take a holistic approach rather than just focusing on the AML requirements, which obviously are critical and are core to this. However, it's not just the FATF recommendations and requirements and the AML legislation. It's so many other things that are happening across the board, and including technological advances, which are going to be a big part of compliance with all of these requirements. So, and as my colleagues have said, the accounting professional and ethical standards are also a critical part of this. There's a whole regime that surrounds those. So I think, yes, it is critical to take all of these things into consideration and the overall impact on reducing ML and TF.
Okay. We did receive some evidence today in relation, I guess, firstly with respect to the modernisation of processes and the use of technology, which is bringing down compliance costs, which is quite favourable to all the participants in this process. There was some evidence provided with respect to cost of compliance. I'm just interested in terms of what the latest information is coming out of jurisdictions like the United Kingdom and New Zealand with respect to cost of compliance, especially for smaller service providers. Australia is a country with vast areas and regions, and many of the members of the profession will be providing support to small regional centres. And I'm alive to what impact the imposition of additional compliance will have on those small accounting practices and the service they provide to their community. So I'm interested in any further information you've got around cost of compliance in jurisdictions like the United Kingdom or New Zealand.
I'm happy to start from a New Zealand perspective, if you like. We've had a lot of feedback from our small and sole practitioners based in New Zealand that the cost of compliance is quite excessive and not really in a risk-reward sort of balance when they're actually looking at the benefit that it's actually giving back to both the system and the integrity and also the consumer. The complexity of the framework that they have to comply with means that they have resorted to outsourcing their CDD obligations because it is such a process to go through, and that can cost anywhere from $50 as an individual through to up to $500 depending on the different structures that are actually there, and such as trusts that Ben had alluded to before. So, we're very mindful that there is an excessive sort of cost that's coming through in that New Zealand framework, and we wouldn't want to see that replicated here, especially because, as to your point, it's going to be passed on to the end consumer because the small business, being the professional accountant, often can't absorb those costs.
So, Ms. Waller, is it possible for you to take on notice that issue, because it's a very, very important issue, and we did receive evidence earlier today that basically was along the lines of that some of the information being provided or submissions being made around cost incurred by professional services firms is overblown. It's exaggerated, and there's a bit of a henny-penny approach being undertaken by some of the professional services firm agencies in terms of the cost. So is it possible for you to take on notice and provide additional information with respect to what your members are actually seeing in New Zealand?
Yeah, definitely.
Senator Scarr, can I make one other suggestion? Would it be possible for the Secretariat to provide a Hansard of the evidence that's been provided on these cost issues and ask the witnesses if they'd comment on that in addition to your question, just to get because it's quite a marked discrepancy between the evidence we've seen from some of the submissions and some of the material we've seen today. Would that be acceptable to you, Senator Scarr, if we get those two things put together?
I think that's a very good suggestion, Chair, because from my perspective, this is a key point, and there is a discrepancy, as Senator Carr has alluded to. So I think that would be very helpful. And I actually think it's extraordinarily important for each of the professional associations.
Yes. So, but I think it's important also to get an understanding of what's actually being said in regard to new technologies and the areas of activity that are subject to compliance costs. I mean, there could be some argument about what it is we're actually measuring. So if we can actually look at the evidence that's been presented, and then you can make your own judgments, in terms of the validity of the claims that have been made.
May I also add, in terms of costs, it will obviously be dependent on the requirements.
That's what I'm saying.
Yes. So if you look at the UK example, which has a very complex system, I'll give you one example of cost. Software that we have until now, up until next month actually, provided free of charge to our member firms to do some of their CDD work. That is now, it's no longer viable for us to provide that free of charge. So that's now going to be provided at a cost of £260 annually, which is about $475. And that's for the small firms. And the majority are very, very small firms. So that is one cost. And then, of course, there are the levies that they have to pay as well. So all of those things would have to be taken into consideration.
Indeed.
The last question I have is really around the role of the professional services organisations. And from my perspective, I think it's going to be absolutely fundamental as the law is reformed, it rolls out to tranche 2, that the professional associations work hand in glove with the government in terms of coming up with the right policy mix for each of the professions and making sure that the system is as effective and efficient as possible. Because it seems to me the professional associations are going to be at the coalface in terms of rolling it out, assisting their members to get up to speed with the new regulations and introducing it in their practices. I'm just interested in your thoughts with respect to that proposition. Is that a fair comment?
Certainly, I think it is, Senator. I mean, our experience in New Zealand is certainly that what we need to be doing is working very closely, I guess, with government, as not only is the legislation, I guess, designed and then the subordinate legislation and regulations, but also that implementation part and guidance and so forth. I think it's got to be a very collaborative process to really, as we indicated, probably leverage what is already in existence for our members effectively, and then, as you say, work out where the gaps are for where there is additional bits needed to, I guess, take it up to the level of FATF requirements. And certainly what we did find out through the New Zealand experience is the implementation time is really quite key. It can be quite an uplift for some member firms, and so we need to actually work very closely with them and build that through into their processes so that they are ready when it actually becomes effective. Because often these things do take time following the passing of legislation to actually come up with what this means in practice.
Can I just add to that? Having gone through 12, 13 years of this know your client obligations and assisting issuers, I still have members today ringing, asking how they ID certain types of individuals, certain types of companies. Different products have different requirements, and so there is a lot of confusion still 12, 13 years into the regime. the simpler and clearer you can make it up front, the easier obviously it is over time to roll it out. But if you create a highly complex requirement for a particular profession, then it can go on a long time.
Well, can I add to that question? In other areas of industry policy, where there's a change in compliance, it's not unknown for the Commonwealth to provide assistance to industry associations to assist industry firms come to grips with the new regime. Would that type of a program for a limited period be of assistance? Now, it may well be that in some areas of regulation, there'll never be a point at which firms actually come to understand things. I mean, I know in the R&D tax area, I know there are firms that constantly manage to get have a misunderstanding, many years after it was introduced, and they rely on taxation accountants who might end up at the practitioners board because of their misunderstandings of things. That is, the accountants themselves end up at the practitioners board. So with that principle of industry associations being given some temporary assistance to actually assist in a transition for a new regulatory regime, would that be of any value?
I would like to comment first and say I think that would absolutely be welcomed by the profession. What we have seen, especially in our smaller and sole practitioner firms, is that they have undertaken a significant amount of reform and regulatory change in the last 24 months. And what we've especially seen in the last 12 to 24 months is the impact of COVID and trying to support their SME clients through that change. They've had significant capacity issues. They've had to invest in a lot in moving remote working in areas that had locked down for long periods of time. And that's had a considerable impact on their capacity and their resourcing and obviously their financial means as well to be able to implement more change. So we would definitely welcome that opportunity.
Okay.
Yeah, and can I just add that, assisted compliance, I think, is something that's being used in the UK quite effectively. So, as Ketty said, that would be extremely welcome.
And in the United Kingdom, how did it work? How did that industry support work? Can you explain that?
I think it's worked in different ways, so that they've looked at things like, for example, whether certain sectors need to have exemptions. They've assisted them with their understanding and education and awareness. And they've assisted them with how different parts of the regime apply to different sectors. But I think the problem with the UK, from my understanding, is that it's so overly complex.
Okay, so you've got some philosophical objections to the regime, but I'm interested in how the government in the United Kingdom assists firms to come to grips with the regulatory regime. Now, are you saying that the government provides assistance through industry associations for that adjustment?
Yes, it does. It provides assistance, but also it's a very different kind of regime.
Yes.
Because they've set up OPBAS, as it is, which is a supervisor, and then they've authorised professional associations to be supervisors. So there is assisted compliance, and I don't know if that's exactly what you're getting at.
Look, as a former minister, we provided management consultancy services. This is the Labor government provided management consultancy services through Enterprise Connect, for instance, which would work with industry associations to lift the capability of firms in a whole range of areas. But, the biggest problem I find in terms of working with my historic experience is moving from a small enterprise, moving from, say, a trade firm, moving into a larger, understanding their regulatory requirements, even for basic requirements such as payroll. Now, you're dealing with this on a daily basis. You're actually providing a service to firms to meet their regulatory obligations. That's what taxation and various other financial services provide on a daily basis. Now, if the Commonwealth's asking for an additional level of compliance, well, then maybe there's a case for there to be further assistance so that people understand what's required and takes away the argument, it's too hard, it's too difficult, it's too costly. We're being told there are a range of ways of dealing with that to minimise costs so that we understand the nature of the ask. It's not the same as the Commonwealth Bank, but it is certainly a requirement to register, particularly when the beneficial ownership test and such matters are critical to our capacity to defend the country against corruption. Then maybe we have to provide some assistance to small enterprises, and in your case, financial service companies, to be able to provide that. That's the argument I'd put to you. We have done it in the past, I know in my direct experience. Is there a case for it to happen in the financial services area as well?
Yes, I think definitely there is a case for it.
Right. So, Senator Scarro, I've intruded on your questions. Have you finished with that?
No, I was happy with your intrusion. You're a welcome visitor, so I'm happy to pass back to you, Chair.
All right, no worries. Well, if you're done, because as you know, I'm looking at the clock. Always looking at the clock. So, Senator,
I'm done.
Are you done? Thank you, Senator. Is there anyone else? Any of our other colleagues have questions? If I could ask our secretary to make inquiries. And Senator O'Neill, if you're keeping an eye on the clock as well, I'll turn it to you. Okay?
Thank you very much. I just want to be clear about your submission to us today that I did hear you say we welcome moves to strengthen AML CTF. You're aware that Tranche 2 is a long time coming. Is there now some acceptance amongst the accounting profession and Financial Planning Association that it is inevitable now that Tranche 2 must proceed?
Yes, Senator, I think certainly from the IPA's perspective, it's something that, we've been involved in consultations from the days of the Attorney-General's Department for many years, really. So I think there has been an expectation that Tranche 2 will be introduced. So I think that it's just a case of, if I could say, when rather than if.
Much promised, but undelivered. I wasn't involved in the 2015 MER, and neither was I involved with the 2016 significant review. And I don't know if you've had a chance to look at submission 32, which is from the Border Force, I think, Department of Home Affairs submission to this inquiry. They've gone at the end of their submission to track what happened with the 84 recommendations that no doubt you were a part of the consultation back in 2016, which was when the government was promising to do this. A lot of water's gone under the bridge between 2016 and now, including the Royal Commission and changes that you've been talking about here in terms of regulatory change. But this is a massive body of work that remains unattacked. So are you concerned about the wastefulness of, having gone through this process in 2016 only to have to really recommence it here in 2021?
I suppose from our perspective, we thought that sooner or later it would happen. There's so much regulatory reform that goes on constantly. It's relentless, really. So I suppose, and I was involved back in 2015 and 2016, and I remember presenting before the Financial Action Task Force and being, almost interrogated, as it were. So I do have memories of all of that. But I suppose it's just a case of, here we are. It'll happen when it happens. It's not something that's within our control, but it's, there is so much other regulatory reform that happens, and I suppose we just wish to ensure that all the regulatory reform that has happened since 2015 and 2016 is taken into consideration.
Yeah, because it's a bit of a dog's breakfast, as you describe it. There's a little bit here and a little bit there and a little bit over here. And there's no clarity, I think, for the sector about exactly what now might have to happen. So I guess my first serious question to you is, has the government discussed with you, any of you in your organisations, their plans as of today to implement Tranche 2 that will cover your profession?
I can't speak for the others. They can speak, but not with the IPA.
So it's still somewhere on the horizon, but not a focus for government, and certainly not a conversation that's live for you, and you are representing, if I can go back here, the Institute of Public Accountants.
Yes, correct.
Okay. So could I ask Miss
Stiliano?
Miss Waller for the CPA?
No, we have not had any direct conversations.
So this is not an item of work for the government, and you are not in conversation with them about that tranche 2?
We've not had a direct conversation on tranche 2 recently.
Ms McWilliams for Cairns?
Likewise, we have had no direct conversations with government around the current status of this.
Of the tranche 2 reforms
Yep.
to AML CTF, yep. And Mr Minchin? Is it Martian?
Martian.
Sorry.
Martian. Sorry. No, that's all right. So as I noted in our introduction, financial planners are already item 54 reporting entities. So we're already under the AML CTF Act and part of the regime. Tranche 2 is not something that we've had a discussion with government about because we are already within.
Yeah, so you're within Part B of tranche 1 based on your evidence, but you have not, I want to be clear about this, that you will still be impacted by tranche 2, but you are not in any conversation with the government currently around tranche 2.
No, that's correct.
Does it surprise you then that recently in Rome, at the G20, Australia signed off with the Leaders' Declaration on AML, CFT and CPF, reaffirming our full support for the Financial Action Task Force and the global network, stressing the relevance of risk-based approach of the FATF recommendations with the aim to ensure legitimate cross-border payments and promote financial inclusion, among many other things. Does it surprise you, Ms Stiliano, that the government continues to herald its action on FATF regulations overseas, yet they are not engaged with you at all on tranche 2?
I can't say that I'm aware of what activities or discussions the government has had with others. I can only comment and say that they haven't had any with us.
Mr Martian, are you aware of this international stance, looking like we're a good international citizen but not doing any of the work at home?
I'll be honest, I'm a little bit more focused on my kindergarten child's reading ability than following what's happening in the news in Rome. So no, I haven't followed that, sorry.
Okay, but it does matter how Australia is represented. We are part of an international economy, and money is moving across borders all of the time, and your clients, your members would be critical in the ethical movement of that money. So it does matter what we present to the world as our public face, doesn't it?
Yes, I suppose it does, but it's just not something that I can really comment on.
Thank you. Ms McWilliams, do you have a comment?
No, I think as we've indicated, Australia has committed to implement the Financial Action Task Force reforms, but I guess it's a matter for government as to when those are implemented in terms of timing.
And based on evidence we received this morning and confirmed in submissions, are you aware that Australia is one of the being described as a laggard in implementation of tranche 2?
I am aware of what's been written in some of the submissions and what's been written in the media, and I have looked at the FATFA website.
So, in your view, Ms Stiliano, is there any other significant legislation that you consulted with this government on as far back as 2015 and 2016 that remains completely unaddressed? Or is this it?
I think that there might be examples along the way, but nothing that is relevant to this.
So this is a pretty big oversight by the government not to implement this, despite its rhetoric to the effect that they were actually doing it.
I think it's really just up to government. Mm-hmm. It's not something I can comment on.
In the 4 years since the government promised a cost-benefit analysis of regulatory options for designated non-financial businesses, has there been, to your knowledge, any effort whatsoever to start that cost-benefit analysis process, which is so important to you that you've given evidence about it this afternoon?
Not that I'm aware of. It is something certainly that we would definitely emphasise, and I know that back in 2015-16 the Attorney-General's Department did recommend that, and is something that we would definitely seek to happen.
But there is no idea currently, there has been no work done about the financial implications of Tranche 2 on your members, is that correct?
Not that I'm aware of, apart from what we've been doing ourselves.
I'm surprised you didn't actually have that information from the government years ago, but I am particularly concerned that as we sit here with international declarations about supporting the FATF reforms and Tranche 2, that the government has not interacted with you to get a cost-benefit analysis underway at all. It would be useful for your members, I'm sure, and I'm sure they'd be interested in knowing what that might be. You've spoken about New Zealand, you've also spoken about the UK. In terms of those jurisdictions and any others, are you aware of the effects of the implementation of Tranche 2-like reforms in other jurisdictions and their impact on viability of businesses? I mean, I know that there's a cost in change. What has happened in terms of other jurisdictions? Has there been a collapse of the industry, or has there been significant failure of small or medium businesses as Tranche 2 is implemented in other jurisdictions?
I don't have any particular knowledge of that, only what I've read in other submissions, but I don't have any particular knowledge of other jurisdictions.
Okay. Mr Manchin, have you got any response to that? Do you know anything about other jurisdictions and, you know, the loss of financial planners?
I know plenty around other jurisdictions and the loss of financial planners, but not in direct relation to money laundering and terrorism financing laws.
Okay. Ms Waller?
I'm not aware of an impact on the viability of any of the businesses for professional accountants. I know it's had a cost impact, but not around this, the continued financial viability.
Okay, and Ms McWilliams?
What our experience has been with New Zealand, and it's important, I guess, to note that the New Zealand regime is activity-based, so it's based on whether or not you undertake a captured activity as an accountant, as opposed to just whether you're an accountant. We do know that, I guess, some of those smaller firms who might have only undertaken 1 or 2 captured activities a year have, I guess, moved away from doing that work, so that they are not part of the regime, as opposed to those who perhaps do a significant amount, who are therefore fully within it. So I wouldn't have said it's affected their viability, but we have seen, I guess, some firms probably cease some of the services that they provided in order to, I guess, be able to continue to service their clients at that lower cost,
so
where they are in that smaller end.
So in some ways it could become a specialised field with some people carving themselves out of it.
With it being activity-based, it is based on those higher risk activities. So effectively, members are choosing not to do higher risk activities that are captured by the regime, and seeking to, I guess, focus their efforts on lower risk clients, and therefore able to just sort of stay servicing them as they would have done normally. But it would have been those that were sort of only had a few, I guess, clients that might have been in the higher risk, or a few pieces of work for them that were considered higher risk and captured. It was very much on that border.
Could I ask if you have any significant interactions with AUSTRAC currently?
We've had IPA that has had interactions, not recently, but certainly over the years in terms of training, education, awareness, that type of thing.
But you wouldn't call it an ongoing and intimate relationship with AUSTRAC? You don't report significantly to them?
No.
Right. Ms Waller?
No, similar.
Mr Martian?
Yes, so the Financial Planning Association has not scheduled but somewhat regular meetings with AUSTRAC on a variety of issues on a regular basis, and 2 to 3 years ago, AUSTRAC worked with the Financial Planning Association on doing a post-implementation review and to get an understanding of how financial planners were engaging with AUSTRAC, engaging with the ID verification obligations around the risks in terms of the services they provided in terms of anti-money laundering, counter-terrorism financing activities. So yes, we have dialogue with them. I can ask them questions when I need to without any problem.
But you'd say your last formal consultation with them about it was, what did you say, 2 to 3 years ago?
No, that was a specific consultation. Whenever AUSTRAC update rules and make changes to their rule books, we are involved in those consultations, and we'll have conversations with them about those changes as they relate to financial planners.
Right, and that's because you're captured in Tranche 1, Part B.
Correct.
Great. Ms McWilliams?
We don't have regular engagement with AUSTRAC. I think to Vicky's point, we've had some ad hoc engagement with them over the time with various bits of guidance, but it's been very limited.
Once Tranche 2 is implemented, you will have an incredible asset to share with AUSTRAC in terms of reports of anything that you see that you think is suspicious or unclear. And as was revealed today, I think in evidence from the police representatives, they would have comparative sightings across the industry. You know, like if you're a big tier 1 company, you might have 5% of your transactions that you would say this needed a little bit of an investigation, report it, and then AUSTRAC would get onto it. What change do you believe and what benefits to the Australian system and international finance will be unleashed when Tranche 2 is implemented and your respective professions are engaged?
What benefits? Well, I suppose the idea is, in terms of the objective and the objectives of the legislation, that the wider the net is cast, so to speak, that more activities, suspicious activities, potentially illegal activities might be caught in that net, which would benefit the economy more broadly. And I suppose I'm going by the policy objectives in the legislation, which, you know, we've always supported. So I suppose to us that's certainly one of the main benefits.
Is there anybody who wants to add anything to that?
Yeah, I'll make an additional comment if I can, please.
Thank you, Ms.
And just
Waller.
say, and I'll just say, I think if we have an ability to collaborate and look at how Tranche 2 is implemented, so we have some cohesion across obligations, be it through ATO, the Tax Practitioners Board, Corporations Act, AUSTRAC, so we can have a level of consistency. I think that'll bring a level of integrity to the system. I think the other thing is a potential level of efficiency. So at the moment, as Ben alluded to in his opening comments, there can actually be different points of having to go through some of those CDD obligations because it's not always accepted by all parties. If we can look to actually bring that together and have a consistency in recognition and one point of verification that could be shared, that could give a lot of efficiencies and integrity to the system.
Absolutely. You actually, this
Sorry,
next... Yes, Mr. Martian.
I was just going to note, we obviously have been involved in reporting suspicious transactions to AUSTRAC over the years. The reality is, and AUSTRAC confirmed in their review, there's virtually none that come through financial planning because the relationship between the financial planner and their client is of a type that financial planners are generally across enough information and the financial position of the client to be on top of those kind of risks. And financial planners often won't engage with clients when they see risky types of behaviour, but will also report those through because of their professional obligations that they have. So there's been virtually no suspicious matter reporting that's come through financial planners as a profession. Because of the relationship that planners have with their clients. And when they tend to have been where the tests for suspicious matter reporting have been set in such a way that, for example, somebody doing renovations or building their house are taking regular payments or regular amounts of money or transferring regular amounts to different builders and contractors and things like that tends to have triggered the reporting programs rather than there actually being anything suspicious to report.
Nonetheless, I expect with the profession, the breadth of the profession that you're representing there, once you've got the skill set and you know how the system works, there is the old expression, a gun for hire, and we've actually heard today about professional service providers, and I do put that in inverted commas, that are advertising their services to overseas entities about how to get around Australian law. So, I mean, there are unethical operators in every industry, and I'm sure that there would be some who, after a period of time of skilling up, could become literally a very valuable asset to somebody who wanted to launder money within the country or from overseas. So I guess there's a reason for capturing that, isn't there? You raised the issue of overlaps and duplications, and we had some evidence live today about that with the Tranche 2 requirements and current professional standards. Could I ask you just to take on notice anything that you think in addition that you want to alert the committee to? Where are the aspects of Tranche 2, to the very best of your knowledge, already covered in Australian law? If there's anything further that you need to add to what you've already put on the record, I'd appreciate having that. Senator Carr asked a little bit about collaboration and the costs of doing so and the benefits of doing so. The UK implementation was focused on collaboration with industry bodies such as yours. How can the government best work with you to ensure that these reforms are implemented in a way that doesn't result in onerous regulation on your profession, while still getting the job done and restoring Australia to the good books in terms of international corporate participant in the world economy?
I think one of the benefits... Oh, sorry, Vicky.
No, you go, Kitty.
I was just going to say, I think one of the benefits of working with the professions like ours is that we have the ability to engage directly with our members who will be implementing this at the coalface. And quite often what we see is policy intention or legislative obligations that we're looking to actually achieve an outcome. But when it gets to that implementation or how it actually goes to unfold, we don't always hit the mark. So I think that if you actually engage with the profession and we actually use that as a conduit through to the members who will be actually implementing this at the coalface, understanding existing systems, the processes and how that can actually come into a day-to-day setting, you'll actually get the best outcome because you'll be able to leverage what's already there, understand how it's going to unfold and ensure it's going to actually fit that policy intent.
Which makes it even more inexplicable why you are not being consulted by the government at all, given your knowledge. Did you want to add something, Ms. Stiliano?
No, I was just basically going to agree with what Ketty said. It was I was going to make similar points that, you know, it's the sort of stuff we've already been talking about. And I think to your point, Senator, previously where you talked about where is Tranche 2 already covered in the existing requirements, I think that sort of mapping and stock take will be very, very critical as we move forward.
If I could ask you, Ms. Waller, you indicate in your submission very clearly you're supportive of applying Tranche 2 to the gatekeeper businesses. What kind of regulatory framework do you think would be most effective to implement? And also, what kind of whistleblower protections do you want for your members?
In terms of the regulatory oversight of what we'd like to see, I think it's about working with that existing framework. So we've already spoke about the fact that there are obligations under the tax profession and under the TPB obligations. We also have obligations under our professional code of conduct without no-clear or non-compliance. So I think it's about if we can actually look at how we can bring those obligations together so we're streamlining those, that'll have the best impact. In terms of vessel protection, I think the same sort of protections that we would expect, and we already have in some of these places, is ensuring that they've got legislative protection. I think one of the challenges you see is when you're dealing with a small business and if you have someone who comes in who may have a suspicious activity, that they would be quite readily identifiable if they actually then report that individual. So we need to ensure that we put protections in place that we're going to protect these small practitioners and small professionals so that they're not going to be a target if they actually are doing the right thing and reporting this non-compliance.
Okay, that's a very good point. Did you want to add anything, Ms. Stiliano?
No, that's fine, thank you.
Thank you. Could I ask all of you to see if you have a view about this? Ms. Stiliano, you talked about the structure in the UK setting, and I understand with the law societies in that country, there's 3 different jurisdictions and they've got slightly different models, etc. We've got jurisdictional challenges that have become very, very obvious to us during COVID. I'm kind of interested in your view about what would be the best way to proceed. You know, is AUSTRAC the appropriate place with the sufficient expertise? Does it have adequate resources? Does it have the right people to implement and monitor Tranche 2 successfully in terms of capturing your profession? If so, yes, why? And if not, why not?
My understanding is that AUSTRAC would need additional resources if Tranche 2 was to come into play, given that, you know, there would be up to, you know, potentially 100,000, you know, different entities that would need to report one way or the other. So as with other regulators, it's, you know, we're constantly saying to government, please ensure that they're adequately resourced to do what they need to do. You know, for example, with ASIC and the ASIC industry funding levy, you've seen what's happened there.
Especially with financial planners.
Yes, especially with financial planners. And we're also advocating for the similar relief for liquidators and auditors, I might say. However, we don't want to be in a similar situation where it's, you know, the profession and industry that's bearing the cost through increasing levies. And I know that in the UK there's a levy paid to OPBAS, for example. So we don't want to be in a situation where you know, there's another cost to industry and to the profession because AUSTRAC or whichever agency it might be is not adequately funded and resourced. I mean, at the moment it looks like AUSTRAC is at the moment, and I stress that, the most likely candidate to take this on, but that's really something else that I should imagine will be subject to consultation.
You would hope so.
I would hope so, yes, exactly, Senator.
But it is a few years in between, shall we say, in terms of consultation. 2016 to 2021, it's definitely not a love affair, is it?
Well, I think there's a lot to be consulted on in terms of Tranche 2, and if we were to start today, I don't know how long it would take, but I would certainly hope that sufficient time would be given to careful consideration, including a cost-benefit analysis and all the other things we've talked about.
Does anyone else want to add anything to that? Is AUSTRAC the best place to be managed?
I think not just, I suppose, talking about whether or not it's AUSTRAC the best place, Senator, and I wouldn't want to I'd probably echo Vicky's thoughts on that. But I think if, to Vicky's comments around, you know, ensuring it has sufficient resources, I think that also comes to that earlier comment about actually working in collaboration with the industry associations, such as ourselves, to actually ensure that, I guess, we provide the necessary knowledge and understanding of the sector to those people within AUSTRAC who will be, if it is AUSTRAC, who will be regulating and supervising the sector. Certainly our experience in New Zealand is that it took a bit of time, I guess, for the supervisor in New Zealand to get actually up to speed on the various differences across the Tranche 2, I guess, professions. They're not all the same, and in fact, they're actually very, very different. And so that does require quite different knowledge and understanding. And I think it's certainly my point would be for whoever is going to be doing that to work very closely with the relevant industry associations across the Tranche 2 professions to ensure that actually there is that understanding of how it will work.
Can I ask one final question? How confident are you that the professionals who have incredible licence because they are considered a profession, and there's an ethical stance that's embedded in the whole concept of a profession because there's so much power. How confident are you that yours is a clean industry, that you haven't got people in there who are making their wealth out of facilitating exactly the kind of behaviour that Tranche 2, which should have been implemented a long time ago in my view, is designed to prevent?
I think that no matter how much you legislate or regulate it would be virtually impossible to ensure that there are no bad actors and no bad players in any profession or in any industry. All we can hope to do is minimise it, and I think certainly when you look at the professional accountants, being the members of the 3 professional accounting bodies, we have robust systems in place that have been in place for, approximately 100 years. So, there's a certain level of confidence. The accountants are called the trusted advisors after all, according to a lot of research and surveys, and that's something that they take very seriously. And our job and role as professional associations is to make sure that we do everything so that they maintain that trusted advisor status. However, I would make a distinction between members of the professional accounting bodies and those who are not members of the professional accounting bodies. So, because accountant is not protected at law, so there might be some out there who call themselves accountants. We have no regulatory oversight of those people, so I would make that distinction.
It's a little bit like cosmetic surgeons in another inquiry we had the other day. They're actually not surgeons, and they're operating in that way. Can I, though, remind you of the recent media reports about the practices in auditing companies, where there's been gross breaches of professional standards, with tests being, taken with people having the answers already prior to going into them. So do you remain, in the context of that reality, confident that the standards of ethical behaviour are really robust, or are they being eroded by, practices of making money over practices of doing the right thing?
I think the point to emphasise is that there are consequences, so that if people do breach the rules and the regulations, that there will be consequences for doing that. And I think that's what sets the profession aside from the others, if I may put it that way.
I guess the consequences in that sector only came because of a US regulator, not an Australian regulator. Perhaps there's some warning there.
Yes, and I suppose there's something to be said for the fact that they were self-reporting, but I'm not going to get into that.
Thank you very
We should get into
I appreciate it.
Thank you.
And I would thank you all very much for your attendance today and the advice that you've provided to us. There's a couple of procedural matters I need to conclude before we wrap up for the day. I'll take, Senator O'Neill, you'll be moving that all documents that have been presented for tabling have so agreed.
Happy to move that way, Chair.
Thank you very much, and there's no objections, so we agree with that. And there'll be deadline, the return of questions on notice. We propose the 3rd of December. Would Senator O'Neill, you be happy to move that way?
Yes.
Thank you very much. That's no objections. That's agreed. And with those formalities, I thank you all very much for coming today and giving us your time, to each and every one of you. That concludes today's proceedings, and the committee will take all questions on notice by the 3rd of December. And I thank all the witnesses that have been in attendance today, and I thank the Hansard and the broadcasting, and I thank the Secretariat for their assistance today. And we'll resume tomorrow morning at 9:15 here. That's correct, isn't it? 9:15 with the Real Estate Institute of Australia. And I declare the hearing adjourned. Thank you very much.
Thank you, Chair. Thank you.